Yes, please, Your Lordship. My lord, I have filed an additional affidavit in respect of item number 41, my lord.
41.
That may be called for, my lord.
41.
My lord. Obliged.
Item number 25, madam. With the consent of the other side, I am making this mention, my lord. Can it be on 23rd of July, madam? Both the senior counsel has agreed for a date, my lord, on 23rd of July. There's a
Item
hearing.
number 25.
Yes, item 25.
I bring that to 23rd of July.
23rd of July, madam.
It's a hearing day. Okay, 23rd.
And there's an interim date may continue, madam.
Interim be continued till next year.
Obliged.
Item number 13(1)(3) with the consent of the other side, madam. Those parties are trying to explore settlement. May I request that this matter be deferred by 4 weeks? 1(3) item number.
Probability of settlement.
Yes, ma'am.
You are appearing for
The petitioner,
your good name?
K. Talukdar.
Mr. Ketan, counsel for the petition. And with the consent. Other side is available here.
He is on your honor.
For the respondent, June 24th.
24th June.
Yes, Ketan and counsel. 8.9 stating that the talk of compromise public settlement is going on between the parties and hence some more settlement. After 4 weeks, 24th of June, you are saying?
24th.
Okay.
No, there's an interim order that may continue.
24th of June, interim order be continued till next year.
I am grateful.
May it please, Your Lordship. Madam, item number 12, madam, with the consent of the other side, may I pray that I am not well today, my lord. So, my lord, matter may be taken on next Thursday, my lord, 25th May, my lord.
It may not be possible.
Madam, as suggested by the other side,
No, already listed.
my lord. Then, my lord, a short date, madam.
Short date in a sense, in the first week of June, probability will be there. Third or
My lord,
fourth?
any,
Yeah, 3rd of June.
May I please?
highly obliged.
Was there any interim?
No. Interim, my lord, that is interim is there, my lord. They are already, I is, my lord, disposed of.
Okay.
May I please, Your Lordship? I'd like to mention item number 27, Your Lordship. I'm for the respondent, Your Lordship. With the consent of the other side, Your Lordship, kindly matter be fixed on in the first or second week of June, Your Lordship. 7.
But 26 and
Yes,
7
Lordship.
are
I have
connected.
taken the consent, Your Lordship. They have given the consent, Your Lordship. 26 also same petitioner, counters are same, Your Lordship.
Same council.
Yes, Your Lordship.
In 26 only state is there, na?
Yes, Your Lordship.
And in 27, the respondent, other respondent is also there.
Yes, Your Lordship.
So you are appearing for which?
K.M.
petitioner?
Hassan, Your Lordship. The respondent, Your Lordship.
Oh, respondent. K.M. Hassan.
Yes, Your Lordship. He's out of station, Your Lordship.
Something the learned counsel appearing for Mr. K.M. Hassan for the response number 1 in criminal revision petition 311 of the 2025. Read 1 and 2. State that the consent has already been taken for the from the other side. Yes, when it can be.
Second week of June, Your Lordship. And Your Lordship, the petition stated that there is interim date, Your Lordship. We will continue.
We listing both the matters on 15th of June. In
Yes.
interim was there.
Yes, Your Lordship. Petitioner statement that his interim is there, Your Lord, to continue.
There are two criminal, one is petition, one is criminal revision.
That-
Interim is there in criminal petition. I think.
Yes, I am not aware which one.
Interim, if any, be continued till next year. Be continued. Okay, we are listing it on 15th of June.
Deeply obliged, Your Lordship.
Wait, please, Your Lordship. So, item number 24. I am praying for an adjournment today, Lord.
20.
24, Lord.
Yes, 24, we have received any.
My senior will not be available in the second half. That's why I'm praying for an adjournment. So, that Lordship, can it be on second, 3rd June? That's pretty convenient.
First. He's saying on 1st of June.
Can it be on
Will be a
second?
Second. Okay, then 2nd of June we are listing.
All right.
At the request made by the matter is adjourned. However, it is submitted by Mr. Goswami that the CD receipt. CD be retained till next date of listing. Estimate recording in advances. So we can retain the case diary till next.
Lordship, I beg to mention item number 18,
17.
connected with 17, connected matter. But Lordship, this matter is still pending in mediation, Your Lordship. The next date is 4th June,
Still pending before mediation.
still pending, Your Lordship. Another date is on 4th June, Your Lordship.
4th of June.
Yes, Your Lordship. So I pray that the matter may be fixed if possible on somewhere between 15, 16 June. Possible.
1784. Return counsel. The response is submitted. The matters are pending, still pending before the mediation, and the next date fixed in the mediation is of 4/6. In view of this, let the matter be accordingly listed on 17th of June. Okay, 17th.
May it please, Lord. Lordship, I beg to mention item number 39, Lordship.
39.
39. Lordship, learned counsel for the petitioner, Mr. Mintu Soikia, is out of station. Matter may kindly be adjourned for today.
Yes, what is the position of 39, Goswami? 39. Report is not received.
Yeah.
Not yet received. Report not received. Issue reminder. With a direction to the OC of the concerned police station to furnish the report on or before the next day. Was there any interim?
No, Lordship.
No.
No,
Yes, when it can be called
4th of June.
4th of June.
Alright.
Sorry.
May I please, your Lordship? Lordship, I beg to mention item number 32, Lordship. Lordship, conducting counsel, he has some personal difficulties, Lordship.
What is the position of 32?
Submitted.
Charges submitted.
Yes.
You want to, was there any interim?
Lordship,
Interim
there
is
is
up
an
there.
interim, Lordship. The interim may
Now see,
continue.
We can continue your interim up to 15 days with a direction to appear before the learned trial court below. That order can be passed, however, this petition will be disposed. Okay. Or you have any confusion?
Lordship,
Or you have any confusion?
Lordship, the interim may continue, Lordship.
Interim be continued only for 15 days. It will not continue forever.
Lordship.
If you want to take any instruction, we'll keep it up for time being, or let it be on maybe fixed on the Monday, or it can be fixed on Monday if you have some confusion. Okay. Monday ki tarikh? 25. 25th of June. Please. Go. One minimum.
With the consent of the other side, I beg to mention item number 14.
1/4. Yes, you are there, I think.
For the
The consent of the this side. The adjournment is paid by the learned counsel for petition, where is allowed. You want any fixed date here?
Around 12th, if you can.
12th of June.
first week of June, if preferred.
No issue.
If you in the first of June, then it will be on 5th of June.
5th of
Okay.
June.
Was there any interim? You, no idea. No, then we are not going to continue. That's why I'm saying, because otherwise record has to be paid.
Check it.
Hmm?
Can I check? Can I check it once?
You can check it. Otherwise, we have 5th of June. Can check.
There is interim.
There was an interim.
Yes.
Interim be continued till.
Lordship, I beg to mention item number 31.
30.
Bail hearing. TCR is received in this matter, Lordship. Some instructions are yet to be received on our part. That's why we need an input.
Now we have received it this year.
Yes, Your Lord.
31. Heard Mr. A. Mishra, the learned counsel for the petition. Scan copy of the. Also heard Mr. D.P. Goswami, the learned BPLB on behalf of states. Scan copy of the DCR has already been received. However, it is submitted by Mr. Mishra that they need some instructions. They need to take some instructions from the petitions. In view of this matter is adjourned. 1st of June will do?
After 2 weeks, your lordship, date need not be fixed.
Okay, after 2 weeks, as on a date to effect.
Obliged, lordship.
May it please your lordship. I beg to mention item number 10. Prayer for
Item number?
adjournment. Item number 10.
Yes. You are for the respondent or
Petitioner.
you are for the petitioner? Have you taken consent of the other side?
No, we will inform.
Going to inform. Mr. P.U. Lashkar is there. Is there any interim? Is there any interim operating?
No.
And with the consent of the other side, the learning counsel of the petitioner. Your good name?
Sorry?
Your name?
Edeka. A date may be
Edeka.
fixed
Achha.
after 1 week.
Edeka. You want any fixed date or
Any
after
date may
one-
be given, like a date may be given after 1 week.
In that case, 5th of June.
Obliged.
Yes.
Here in this case, Lordship, only non-bailable offence is false promise of marriage, Lordship. Lordship, may I kindly see the FIR page 12. This is typed copy and Lordship, the language used in the FIR, Lordship, may I kindly see. May I read, Lordship? May I read, Lordship?
Yes.
With due respect, I beg to state that I had love relationship with the accused during which he induced me to believe that he would marry me. On such false promise of marriage, an agreement was also executed before a notary. Under the false assurance of marriage, the accused established physical relationship with me repeatedly against my free and voluntary consent. The consent, if any, promise of marriage and thus is not valid consent in the eyes of law. So everything is in view. That on several occasions the accused forcibly committed sexual intercourse with me and also subjected me to physical assault when I resisted his advances. On 10/12/2025, on such incident of forced sexual intercourse, the accused took photographs and recorded video clips of the act without my consent. Thereafter, he threatened me with dire consequences, including making such material public if I disclose the matter. Subsequently, the accused started avoiding me and began demanding money from me, thereby committing acts of extortion. So, extortion word. When I insisted on marriage, he refused and further threatened to kill me. The accused has repeatedly subjected me to physical abuse, sexual abuse, and mental harassment. Recently, the accused has uploaded and circulated the said obscene photographs and videos on various social media platforms few days ago with intention to defame me and destroy my reputation. The said content has also been circulated in public domain and media portals. Later on, when I contacted the accused regarding the same, the accused again threatening to upload more such content and to kill me, thereby causing grave fear for my life and dignity. Due to the above facts, I have been living under extreme mental trauma, fear, and social humiliation. It is stated that the act of the accused clearly constitute cognizable offences punishable under BNS and IT Act. In view of the above facts and circumstances, I most respectfully request you to register an FIR against the accused and take strict legal action against the accused as per law. So this is the FIR. And one thing I'm just pointing out that in that date is there 10/12/2025. One incident is alleged. Since when she is in relationship, that is not there. Because as per my instruction also, for last 2-3 years, they are living together as husband and wife, Lordship. And one thing, Lordship, may kindly note that during on such incident, that date is there on 10/12/2000, during on such incident, the forceful section 1, the accused took photographs and recorded the clips of the act. So here why I'm pointing out, admittedly, one photograph was circulated showing them in a private moment, Lordship, wherein his face and the girl's face was also seen. So no person will circulate a photo showing his face of himself, Lordship. That is my case. In fact, if your Lordship turns to the forwarding report, page 15, relevant paragraph portion, page 16, Lordship, ground number 4. May I read it? The accused has uploaded and circulated obscene photographs and videos on various social media platforms with the intention of defaming the informant and tarnishing their reputation. So his face is also seen in that photograph, Lordship. So my whole case is that it was there, Lordship, it was circulated, I'm admitting that part, but it was not he who circulated, Lordship, because his face was also seen in that photograph. And only that non-bailable offense is that false promise of marriage, Lordship, that she has not disclosed since when they are in, Lordship, relationship, when he exactly refused to marry her, that specific part is not alleged. And false promise of marriage, Lordship, now it is section 69 of BNSS, that is up to 10 years of punishment, 60 days mandatory period, Lord.
Otherwise, the allegations are serious and uploading the photographs of intimate photographs of the victim, Lordship, maligning her reputation also. So it is also a serious offense, Lordship. At the time of account along with the victim statement, I pray for case diary at this stage. Victim statement is required at this stage, Lordship. Because he's
To verify whether these clips were uploaded from his mobile or not, that can be verified from keeping him outside also, Lordship. For that, probably his custodial interrogation is not required. And ultimately, they were in relationship, that is admitted part. If he remains further, Lordship, that may deteriorate their relationship also. That is the one problem. And I have categorically made Lordship statement that he is willing to marry, but she was in relation with other person, so therefore she is not willing. And therefore, this present affair was wrong. Admittedly, that photograph was there, that I am not denying.
Mr. A. Ahmed, running constable. Mr. D.P. Gusa. Learned Mr. P.P. applicant posted response. It's an application under section 20. This certificate is by Mr. The constable petition except the section 69 BNS, the other sections are available under which the case has been raised. For the certificate, admittedly there was a relationship between the victim and the accused petitioner, and petitioner, but thereafter she started having relationship with other, and hence the relationship was broken. Though he is still interested, he willing to marry the petitioner. He further submitted that from the statement made in the FIR as well as from the recording report itself, the scene that the one photograph is made by this in the social media, which is also admitted by the present petition. But in the said photograph, the faces of both the victim as well as the petitioner are shown, and so that was not made by the present petitioner and present petitioner as petitioner as the same will also tarnish his image in this society. But the petitioner is ready and willing to now. However, the petitioner is in custody since 2/5/2026, and considering his period of detention, he may be released on bail. To stop, however, he is willing and however, he is willing to extend his cooperation in further investigation of this case if it is. Next part, Mr. Usami learned additional 50 days objection and submitted that it is not only a case of false promise of marriage, but the photographs of the victim was also made by the petitioner, and accordingly he insisted call for the case study. Next para, hearing the submission made by an other matters in the case study. This court is above then that an interim bail can be granted to the present petitioner during the receipt of the case study. In view of this, will you move to CGM?
Bongaigaon.
CGM. Okay, you'll be under interim bail.
Lord.
But by
Okay.
other conditions. You're listing it when it can be
9th of June.
9th of June.
Obliged, Lord.
Yes.
May I please, Lordship?
Well, this is a regular bail application. Charge-sheeted case, trial is going on. My lord, kindly call for the charge-sheeted case. Kindly call for the scan copy of the
So
trial court
103
report.
is also
One
there.
hundred is there.
Okay, where it is pending, before the court of?
Landed Session Judge Dhobri in connection with
Dhubri.
session case number 22 of 2026.
No, 399. Sessions case number 399.
Session case number 22, only
Oh,
22
acha, 22, acha.
of
Anyway.
2026.
Call for the scan copy of the TCR along with the case time. Rest you will do the needful. Yes, Burwa, when it can, from Dhubri.
Dhubri.
After 2 weeks, any day, my lord, kindly.
11.
Oblige.
May it pleases your lordship. Your lordship, this is a regular bail. The FIR is at page number 28.
28.
28. The FIR, I most respectfully state that my sister, namely Shruti Roy, has been married to Rupak Sen, son of Sunil Sen, resident of Lal Ganesh, Vivekananda Path, house number 102, PO Udal Bakra, since last 3 months. Today on 26/4/2026 at 11 a.m., her husband informed my father that owing to ill health, she has been admitted to Marwari hospitals. I, along with my father, went to the aforesaid hospital and found that she has been admitted to the ICU. In the evening at 5:25 p.m., we have been informed that my sister has died. Sir, we could not know what had happened to my sister and how my sister died. So I pray before your good self to investigate the death of my sister and take necessary action in this regard. I suspect that behind the death of my sister, her husband, her father-in-law, and her brother-in-law, Debu Sen, are there. So on the basis of this FIR, it was registered under sections 103 subsection 1 and with section 3 subsection 5. And the husband was arrested on 27, the basis of this FIR. So actually there was a love marriage which was not approved of by the family of the wife who is the victim here. So that is the reason why, due to dislike and hatred, this FIR was lodged. In actuality, she fell ill on 23rd. And after that, they visited one Dr. Somnath Dev, and various medical tests were also performed. And after that, the doctor, when they went with those results to the doctor again to check out, the doctor advised her to be admitted at Marwari hospitals, where her condition deteriorated. And after that, she was admitted to ICU and she passed away. My lord, may kindly come to page number 48. 48 here, the random blood sugar is 270. She was already diabetic and also suffering from other kidney problems and other things. So these are all readings which show that she was in some problem. And the cause of death certificate, which has been annexed at page number 59, the last page, it has been mentioned as cardiac arrest to be ascertained by postmortem examination, acute liver injury, hypoglycemia, acute renal injury, oil sepsis. So these are the results. Nowhere it has been ticked that it is a homicidal case. So on the basis of this FIR, he has been released. Now 103 is directly for murder.
What do you mean by renal injury and your acute liver injury?
Yes.
Renal
What
injury
is-
is with kidney. With
Kidney is okay. Renal is can be understood. Why it is just as renal injury? It is not the acute disease, liver disease, or acute renal problem. It's not there.
it is not
It's
there.
there only the liver injury. We are not
Injury.
the doctor, so we are laymen. Just I'm asking
Huh.
why this liver injury, not the acute liver diseases or sometimes NLLD or non-alcoholic diseases. These kind of things are there. It's
Yes.
not either nor it is a cirrhosis, nor anything is not written. Only liver injury is
Injury.
written and renal injury is there. So how can we know that what kind of injury or why the renal problem is there? She may be diabetic. I'm not on that. She may be diabetic. That is okay. But whether she was also suffering from any kind of disease, because disease is not, mentioned here.
Disease is
Simple
not mentioned.
injury is there.
Injury is there and
Why
cardiac
injury
arrest.
is there? Just tell us.
The injury is there. That may be due to some medication also. That injury has
And why the
happened.
ward injury is there?
So that has to be ascertained
That
by
has to
an
be
expert.
ascertained. That's what I'm
By an
saying. That
expert.
has to be ascertained.
Certain.
Now, see, if someone kick in this pelvic area or in the right side of the stomach and all, they may cause some injuries. I don't know. We are not only doctors, so we cannot say at this stage. So this finds that otherwise she may be diabetic. I'm not on that. Maybe diabetic, maybe hypertensive also.
Hypertension.
That may be there.
There.
But in
Or
the,
that
in,
maybe it may be aggravated because of those her ailments.
Ailments.
That may also be the one of the cause. But how she sustains such
but
kind
in
of
the
thing?
forwarding page 33, Lordship,
30?
33, round of place number 2. The attending doctor in the MLC submitted before the dispute police station has opined the cause of death as poisoning, which prima facie indicates commission of a cognizable and grave offense. This necessitates a thorough and prompt investigation, including a custodial intervention of the accused to ascertain the
Your
source.
petitioner is in custody since when?
Judicial custody since 27
27th of
4
April.
2026.
Call for a case diary, this is along with the
Calling for the case diary at this stage along with the PM report, if any, already collected. The case diary along with the PM report. Yes, Kusami.
Can it go next week? Next week.
Next
It's
week
full
is not
week.
possible. Not at
5,000.
all. Pardon? 5th of June will be too late for you or what?
If an earlier date can be given,
That will be on 1st or 2nd?
that request will always be made.
2nd of June.
Second, deeply obliged. My lord, it is the FIR is at page number 30. 3030. With due respect, I beg to report that on 8/5/2026 at around 11 a.m., as per information received from police control regarding a quarrel between husband and wife at Empire Residency. Accordingly, as per instruction by OC Hatigao, I, WSI, Judy Payeng of Hatigao Police Station, along with staff accompanied by LNK 674 Kodamali and WLNK 47 Santa Kumari Chetri of Hatigao Police Station, proceeded to the place of occurrence PO. Namely Empire Residence, Block B404, Friends Path, near AIUDF office, Hatigao, in connection with above reference. During the course of visit to the PO, the flat was found locked. After approximately 5 to 10 minutes, one individual, namely Niaz Akhtar Ahmed, arrived at the door of the said flat and stated that the flat belonged to him. Upon questioning him regarding the incident, he does not say anything. Thereafter, he was instructed to open the door accordingly. The said individual opened the lock of the flat using his key, and I, along with LNK Kadamali and WLNK Santa Kumari Chetri, entered the flat along with him. Upon reaching inside the room, two ladies, namely Sayyada Dilshad Hussain and Sayyara Begum, were found present. Upon questioning one of these ladies, namely Sayyada Dilshad Hussain, stated that her husband Niaz Akhtar Ahmed had engaged in an argument with her and had wrongfully confined her inside the flat. She further stated that she wished to go to her parental home at Nagaon district as her husband tortured and confined her several times earlier. Thereafter, when I, along with accompanying staff and the rescued victim Sayyada Dilshad Hussain, was about to leave for Hatigao police station, the individuals, namely Sayyara Begum and Niaz Akhtar Ahmed, started arguing with the police personnel. Subsequently, the individual Niaz Akhtar Ahmed wrongfully confined me and my accompanying staff along with the victim Sayyada Dilshad Hussain by locking the main door of the said flat. Further, both the individual Niaz Akhtar Ahmed and Sayyara Begum abused me and my accompanying staff in abusive language. After that, suddenly the accused Niaz Akhtar Ahmed pushed down one of my staff, Kodam Ali, onto a sofa and physically assaulted him, as well as pressed his neck tightly with intent to kill, as well as threatened with dire consequence, and thereby obstructed the government servants from discharging their lawful duties. The incident was also videographed in my mobile phone. After about half an hour, the officer in charge of Hatigao police station, along with other staff members, also arrived at the spot and rescued us along with victim Sayyada Dilshad Hussain and apprehended the following named persons and brought PS for taking necessary action. Therefore, I request you kindly to register a case against the below mentioned accused person and take legal action as per law. So there are two named accused here, Sayyara Begum and Niaz Akhtar Ahmed. Only Niaz Akhtar Ahmed has been arrested and he is in detention. And the sections that have been registered here is 127(2), 296, 1152, 109, 132, 3512, 35. That means the non-bailable section here is the attempt to murder. So accused number 1 was not arrested, only accused number 2 was arrested. And it is actually simply a domestic dispute.
127(2)? 127.
127 wrongful confinement,
Child
296 obscene acts and songs, 115 voluntarily causing hurt, 109 attempt to murder, 132 assault or criminal force to deter public servant
This
discharging
is
of his
also
duty.
bailable. This is also bailable. 132.
Not believable.
132 is not
Not
billable.
believable.
Can it be a bailable section?
132. Non-bailable. Non-bailable. Cognizable, non-bailable.
Yes, it will be a non-bailable.
So there
Not
was
be
some
bailable
domestic.
one. And
Domestic.
now see the, is it your petitioner is in custody since when?
My lord,
Your petitioner is in custody since when?
he is in custody from 9th
9th of May?
9th of May.
Now see, the FIR is very clear. Yes, Mr.
Yes, he
Sam.
not only wrongfully confined the police personnel,
Yes,
also
yes,
assaulted
FIR,
them.
but then though, how police will go?
Lordship,
Very, I mean, in detail FIR.
Lordship,
How
kindly,
your petitioner.
petitioner is a psychiatric
discharged.
patient.
Then
Kindly come to
he should
page number
behave
42.
In an asylum and all.
Kindly
Should
come
not
to
be there only.
page number 42.
Whatever.
It has been
Psychiatric
certified by a
patient.
doctor that he has been undergoing medication for the last 5 years for his psychiatric
Then family
problem.
members, people should be there. And what was the what the lady was
Or
doing
for a
there?
case there at this stage.
Other
2-3
lady,
police personnel went there, he confined these things and then assaulted
Assault
him.
the police.
the assaulting part
Very
has been
well-
denied in the petition.
Huh?
As per my instruction, that has been denied. There was verbal altercations and abusive language was also used. But on assaulting portion, he has all
It was
denied that.
videographed then.
That
Entire
will be decided.
incident was videographed by
It has been
the
written
lady
videograph.
officer.
That videograph will be decided. Lordship, may kindly come to page number 42. That has
40?
been 42. 42. The doctor who has was certified him, Mr. Niaz Akhtar Ahmed, 30 years old, male, has been under psychiatric treatment and follow-up for the past 4 years. His last consultation was on 8/4/2026 and follow-up was advised after 1 month. As the patient not personally present today, the attendance attended with previous treatment record and has been advised to continue treatment medicines till next visit or follow-up. And we have also annexed his documents. There's a medical documents. He has been constantly under the treatment of
Let us
psychiatrist.
maybe.
So there was
These are
only
denied by us.
a domestic dispute that has arisen, but that culminated into this.
Domestic dispute is okay. For domestic dispute, these two lady may be confined. That is also okay. But why deterring the public servant? 109 may not be also there. I won't say, because there may be some exaggeration that get admitted. But deterring the police servant and how the police servant was misbehaved with your petitioner, maybe he may be a psychiatric patient at this stage. We cannot say. But at that very moment, because he was under medication. So when he was supposed under the medication, their psychiatric problem may not be there. That's why medicine, the doctors advise for continuing for the medicines. Because of it may have sometimes, because during some period is there also. There are some terms are there for these psychiatric patients. So maybe your patient, we're not denying it because there are medical documents. Let us pay the case diary. And what is there any report from your jail authority also? Have you informed the jail authority? Is there any report from the jail authority that he behaving abnormally in the jail, inside the jail?
Take medical
premises?
care, proper medical care.
No, is there any report from you?
No. Not
Have
to
you
my
made any
knowledge.
consultation with the jail authority whether his abnormal behavior is there inside the jail, whether he's creating any problem inside the jail? That kind of thing is not with you.
Not-
So how
I
can
will
you
get
say that
instruction.
he was not normal at the time?
I'll get instruction.
Yes.
Eight of them.
No, he is in custody since when? 9th.
9th of May. 9
of
days in
May.
custody. 11 days.
Second, on second, like the earlier,
First you follow his packet.
Second or two.
second,
Second. Finding. Second.
deeply obliged.
CDB call.
Wait, please, Your Lordship. Lordship, this is a regular bail application. Here, the petitioner in jail custody for 66 days. Lordship will find the FIR that is on page 12, Lordship.
Yes.
May I read, Lordship?
Mhm.
With due respect, I have the honor to report that on 14/3/2026 at about 5:30 PM one information was received from local public of Anchal Para Gaon to the effect that one minor girl was found along with one person, namely Jahangir Alam of Bhalukbari area. On being questioned by the local public regarding the identity of the minor girl, it came to the light that the minor girl name is such and such. PS Sachin was taken away from Bodhuabari Bajar by the accused person on the pretext of false promise, Lordship. Specific allegation against Jahangir Alam. Thereafter, Lordship, I, along with my staff, proceed to the Achal Bajar and ask the victim and the alleged accused person could not give any satisfactory answer regarding the minor child. It is suspected that the accused person, Jahangir Alam, in conspiracy with his brother, this is a Safiqul Islam, present petitioner, has had induced and transport the said minor girl from her native place with a dishonest intention for trafficking and exploitation, and including the possibility of illegal activity as such, forced labor or sexual exploitations. The act of the accused person clearly indicate the human trafficking of a minor girl by inducing and the deceitful manner. The local public further stated that the accused person had illegally taken the minor girl from Gauhati to the another place without the knowledge or consent of her guardian. Hence, it is strongly suspected the accused person Jahangir Alam and his brother Safiqul have committed the offense trafficking and procuring of the minor girl for exploitation. Therefore, it is requested take necessary action and register the case against the accused person as per law. Specific allegation, Lordship, Jahangir Alam, since the petitioner is the younger brother, Lordship, police already, Lordship, booked him, Lordship, for that girl is already been recovered, Lordship. This petitioner is 66 days in jail custody, Lordship. Since girl already been recovered, Lordship, further custodial consideration. That kindly be
So after
considered.
praise of the case record and statement of the victim, Planet Trial Court has rejected the prayer. So I
That
take
is-
a case at this case. Alternative Lordship,
That
Nexus 6, case 19. Last paragraph, taking into consideration the seriousness of the allegations made, materials on record, including the statement of the victim herself, and an essence to the investigation of the case, the court is of the opinion that the accused release on bail is likely that he shall interpret a proper investigation of the case.
Lordship, that was
Victim statement is required at this stage. Lordship.
victim, Lordship, herself stated in the FIR, Lordship, it was taken by the Jahangir Alam, not by this petitioner, Lordship. Considering, Lordship, length of detention, Lordship.
That we don't have. Total of 90.
But Lordship, that co-accused case is pending and it is fixed on 25 of this month, Lordship.
Before this court,
Yes, Lordship.
25 of this month, no?
Yes, Lordship.
They just tell us the number.
BA number 1224/2026.
1224. Okay, 25 CDB 1 for 25. It is still try along with BA number 1224. Okay.
Hello.
6.
May I please, Your Lordship? This matter may be fixed on 29/5/2026, my lord. Along with AB number 1006/2026.
59, we are listing list numbers of matter.
And in that case, CD was called for, my lord, because both the matters arising out of same affairs, my lord.
So 29,
29.
along with Along
And
with-
AB number 1006/26.
AB number 1006.
Oh, Lord.
Yes, send it.
Lordship, may I please, Your Lordship? Lordship, FIR is on page number 9. So allegation is a death of a person, though
So I'm seeking it's anticipatory bail application, Lordship. The petitioners are just 18 years, just cross the juvenile period, 18 years, some months, Lordship. Actually, may I read the FIR? I say so and so, that my son's Omkar Jha, agent upon even resident, that is the operating for that. Upon tracing and inquiries, I came to know from 4 or 5 women working at Tamil factory, village Nepal Para, that on 4th May 2026, my son was seen in the company of 2 persons in the evening of around 5 p.m., namely Kushal Sharma and Madhav Pada. These are the petitioners. Both residents who had come to the house of his uncle Sri Khelraj Upadhyay at Gaurubasai. And thereafter, two Adivasi person informed that the said 3 persons were seen going towards the Lahoti river in the evening of 4th May 2026. Further, villagers near Sampa village river stated that the 3 were seen taking bath in the river and having fun. That suddenly the villagers saw only above 2 accused persons emerging from the river in the wet undergarments. When questioned by villagers about their near naked state, both ran away, put on their clothes near the river, inquired about the way to Shishutangi, Nepal, Para, and fled towards there. That on 5/5/25, around about 6 p.m., I received information about a dead body found in Sampa River, and I was shocked to confirm that the deceased was my son, Omkar Jha. From the above inquiries and trace out, I am in suspect that the petitioners, both the petitioners, are involved in the murder of my son, and thereafter fled the scene suspiciously. That there is a delay of about 3 days in the complaint, which is bona fide, and due to extreme shock, depression, and grief upon discovering my son's death, I was mentally unprepared to oppose immediately. That I have no enmity. I have no enmity with the accused person, and the facts stated above are true to my knowledge and belief, and based on reliable inquiries and independent witnesses. These are the things. But Your Honor, no matter is that there is a death of my one. He was undoubtedly the person who died. He was my good friend. So the fact is that something else also, that we took bath. It was prior to other death. Other than that, actually our Upanayan was on 6th. But we came from Siliguri to take Upanayan on my uncle's house. That's because we cannot afford it. So we cannot go out on the 5th. That thing is, when we take bath, it was on 4th. It was the day when he died, we cannot, as per our rituals, we cannot go out of the house. But here, my simple prayer, Lordship, in this stage, Lordship cannot. Because these are 18 years, 3 months, mark. Students, they are both students. Only the fact that if something happens, I don't think Lordship, as per parent Lordship, that something murdered had happened. Even they have also stated that they are having fun. Something may have happened. They have taken something. They're small guys, Lordship. Just 18 years, some months, Lordship. So at this stage, Lordship, let me give my statement to the police station. I will let them give the statement. If something good, bad happens, if in the city, Lordship, if they have murdered, really murdered, I don't have any objection also as parents, Lordship, as per from parents' side, Lordship. So they are just 18 years, 3 months, both are students, they have come for Upanayan. As per the statements of the guys, Lordship, they cannot go out of that because Upanayan was there. They cannot go on that day. So the day when they died, when the person died, they cannot go out of the house, Lordship. So it was yes, they took bath. It's the other day, Lordship. They have seen that day they have not taken bath. So that part has to be ascertained, Lordship. The truth must come. We also sing in the pleadings also we are saying this justice should be given to my friend. He was a good friend. Even they have also said we have no enmity. We are good friends. I stayed in Siliguri, Lordship. I have an uncle. So as we cannot afford to that, Lordship. At this stage, Lordship, and
Samir.
The allegations are serious of the case of murder, Lordship. So I pray for case there because in spite of from the place of incidents, they played away from the person as per the statement of the witnesses. So if there is an accident, they can ask for help. They fled away from the
that is true, Lordship.
So Lordship, at this stage,
only Lordship.
If you
Lordship,
have submitted that on that day, they, as per rituals, they cannot come outside because Upanayan was there.
Upanayan was there.
I can understand. Now, what is the reason or what was the ground that local people or these
Lordship, later on, Lordship,
tell a lie that they have seen the 3 people,
Yes, they have seen
because they
other
don't
day,
have
other day,
any
Lordship.
reason.
That
They
is, a-
cannot have any reason because they do not have any enmity, the persons from the local.
yes,
local-
enmity is not there.
That
Enmity
is not there. So they saw those three persons and they also saw that those
Lordship, yes,
two were fled.
yes, Lordship.
So
When
it
they
is
ask-
creates some suspicion.
The
And
suspicion,
it is.
the
also
murder
the
is,
fact that-
murder maybe not
Nah,
there.
and it is also a fact that out of fear and all, they might have fled away. That may also be
Yeah,
the
may-
reason.
may-
I cannot.
That may,
deny.
Lordship, here at this stage, if the Lordship has the power, that is not the ultimate
Okay,
thing.
we call it for the case diary.
In the
Short-
interim, maybe it's possible, Your Honor, that is.
Oh, sorry. 26th is open. 26th is open. We're giving a very short date on 26th of,
Your Honor,
26th of.
26th of May, 26th.
Yes.
Yes, that.
It's from where, but by
Sirang, it may not come, Your Honor. Your Honor,
Srirang will not come, I think.
Srirang from
huh?
Mhm.
You're taking a Lordship, if possible, Lordship, my statement, Lordship, there is not a thing that we are hardcore criminal because we are just 18 years, 3 months, Lordship.
First of
Lordship,
January,
if possible, Lordship, interim, keeping a long,
26 may not come, now, I think.
difficult to come.
Difficult.
Lordship, in this case, Lordship, I'm
May
again,
need a-
When is it?
and test it. 26 may not come, so at least on 28.
Lordship will try.
Lordship, interim may not be able.
Let's see what had happened.
Lordship. Like,
May it please your lordship. My lord, your lord, this is a pre-arrest bail application. Your lordship will find the FIR at page 15. So far the FIR is concerned, my lord, my name does not transpire anywhere in this FIR, my lord. In connection with this case, my lord, your lordship has occasion to go through this FIR and your lordship has granted pre-arrest bail and the matter is now fixed on 4/6/2026.
Is the driver's sister, I granted bail. I think.
Yes, and
Sister
here,
of
my
the
lord,
driver, but
yes,
you-
here, my, so far I am concerned, my lord. Here, my brother has been arrested. Brother is the owner of a shop where the stolen, is stolen, but he says that there are documents to show that it was legally purchased. Now, I am the owner of a vehicle and the police suspects that it may have been used by my brother. That's why they are calling me to the police station. No notice, nothing. I'm willing to cooperate with the investigation. My brother is inside the jail.
Earlier bail was
No,
granted.
one driver was.
Driver and
the-
handyman
the,
was-
The interim was granted to the sister of driver of the vehicle and Somen Boro.
Somen Boro.
Yes.
And who are you now?
I'm the owner of the registered vehicle where the driver,
You were the owner of?
Oh.
You were the
Oh,
owner?
I'm not the, oh, sorry, I'm sorry. Well, the missing, first the truck was missing.
Ah, yes.
So driver and all those things have been arrested.
Ah.
From there, they used a vehicle to transport it to other on rent. That vehicle, I'm the registered owner, but this, all these goods were unloaded in my brother's shop. That's why my brother is inside jail.
So the lordship has granted the petitioner's interim protection, the
Sister.
sister of the,
I can still remember.
yes.
All the persons who are directly involved, they have been arrested by the police. Now they are calling the other persons also for investigation purpose. Your lordship has fixed it on 4th, my lord. I'll go and appear before the investigating authority. If there is direct any material in the case, that then your lordship will see. But prima facie, it appears that there is no direct allegation against me in the FIR.
What is the role and involvement of the petitioner after present of the case where it will reflect?
Yes,
Otherwise,
yes. But
In your shop, everything from your.
Not my shop.
Everything is recovered.
the brother's shop.
Your brother's shop.
Brother's shop. He has been arrested, taken into custody. I'm nowhere connected with that shop. Yeah, local resident, my lord, they will not abscond, my lord, till 4th. Even the vehicle which was used by my brother, of which I am the owner, has also been seized. Now they, as a being the registered owner, I have been summoned that.
By those, that vehicle, the goods were carried.
Well, initially a truck was carrying
that
the
was carrying
vehicle.
the goods. From that
So
vehicle,
from that truck, it was transported for selling it in a Bolero vehicle. That Bolero vehicle, driver, my brother, everyone arrested. Now, officially, I am the registered owner of that vehicle. That's why they have summoned me, but I have no involvement in the theft.
yes, Goswami.
Yes, also going to the FIR, it's not reflected in the any involvement of the petitioner, also. But otherwise.
Investigation only
Yes,
it has come.
investigation reveals it, what is the involvement of the petitioner also. So, I prefer case at this stage also.
Part Mr. Bedi Pond, the learned senior advocate, assisted by Mr. P. Dole, the learned counsel for the petition, also heard. And Mr. P. Goswami, the learned additional VP.
Yes, no order.
It's an application.
On the side here, please, no.
Submitted by Mr. Pond, the learned senior counsel, that the present accused petitioner is innocent. And he is no way connected in the LS. However, it is correct that some articles were recovered from shop of his brother, and he already got arrested in connection with this case. But police is searching for him as he is the owner of registered owner of the vehicle, by which it is alleged that the goods were carrying in the shop of his brother. But till that, he was however, the petitioner is ready and willing to extend his cooperation in further investigation of this case. Until that, he has not received any notice from the investigating officer. And if some Mr. Korn further submitted that if some information is provided to the present petition, he will cooperate and in the further investigation of this case. He cooperate the IO in further investigation of this case. Next, Mr. Goswami, the learned additional people submitted in this report. The city will reveal the actual fact and the involvement of the present petitioner in the alleged offense. Accordingly, he insisted to call for the case. Next, hearing the submission with better consequences. This court is of opinion that an interim protection will be provided to the present petition. Receipt will be based on other matter is listed on 4-6.
My lord.
Other matter is listed on
On 4-6.
List matter accordingly on 4-6. Okay, you will be under interim protection. We are listing it on 4-6.
Yes, ma'am. We'll cooperate with the investigation, ma'am. Deeply obliged.
Wait, so this anticipatory bail application, my lord, lordship will find the FIR at page 12. Page number 12, my lord. My lord, before proceeding towards the FIR, I'd like to point out some facts. My lord, actually, this is the second FIR with regards to the alleged offense. The first FIR was filed by us. So actually, we are the victims. But just to counter our allegations, my lord, this FIR was filed. My lord, may I read, my lord? With due respect, I submit that on 21/3/2026 at about 8 a.m., the accused number 1 mentioned below, along with his elder brother so-and-so, forcibly took my nephew so-and-so while he was passing through the road of our village to their house with some evil intention and started assaulting him. Later on, upon hearing cries and shouting, we came to know about the incident, and when all the members of our family proceeded to the place of occurrence, the accused persons mentioned below also surrendered us and started assaulting us with bamboo sticks and sharp weapons with the intention to kill us. With the help of local people, we somehow managed to save our lives. However, my nephew so-and-so, so-and-so, and so-and-so sustained injuries, and so-and-so and so-and-so sustained grievous injuries. Immediately, they were taken to Chapur PSC, and from where so-and-so and so and so were referred to Bongaigaon Civil Hospital. This basically this got the hospital reference. So, actually, what happened actually? Lordship will find this was the FIR. This FIR was filed on 17/4/2026. Incident happened on 21/3/2026.
This
Now-
FIR filed in 20.
17/4/2026, and the incident was happened on 21/3/2026. There's a long gap.
No, FIR is filed on 17/4.
17/4, yes, ma'am.
An incident?
Incident 21/3/2026. Now, may I take your lordship to the first FIR? Page number 24, madam.
Page number?
24, madam. This was the first FIR. Now here, what I will not read the FIR, my lord. Actually, what happened, my lord? Now the son of one of the petitioners had a quarrel with the victim in that first FIR. And the quarrel was taken place in the premises of our house. And thereafter, my lord, all the victims, as mentioned in the second FIR, those who were the accused in the first FIR, they came out they trespassed our house with sharp weapons and bamboo sticks and brutally thrashed our female members, our male members, everyone. And thereafter, when we are taking those injured persons, we are taking them to the hospital. And in that way, in the midway, my lord, they again surrounded us and they have brutally tortured us and with sharp weapons. Lordship will see, I have also affixed the images, my lord, page number 35. This is the condition of the petitioner number 4, my lord. And that was and the second photo is the mother of the petitioner number 4. This is the condition, my lord. Now, actually, we are the victims here. In our first FIR, my lord, the charges, the dominant charges, attempt to murder. Here, there is only one non-bailable section is there, 118 clause 2, grievous. That too, my lord, either it falls under the right of private defense or it falls under the exception of 122 clause 2, grave and sudden provocation. Now, that is a matter of trial. But prima facie, the incident took place at our campus. They came to our house, they trespassed our house, and they forcibly, my lord, they have brutally thrashed us. And when we filed the FIR on 16/4/2026. 16/4/2026, that was the very first FIR. We lost the FIR. We were busy in treatment. Entire family members, all the family members were brutally assaulted. Once we filed that FIR, my lord, immediately on the second day, the second FIR, this present FIR was filed, against which we have come here for anticipatory bail. And my lord, earlier we filed pre-arrest bail before the trial court, and only on the grounds of grievous injuries. The lordship will find it at page number 23. Only on the grounds of, my lord, grievous injury, my bail plea was rejected. In the cross FIRs, all these material facts were not taken into consideration. Well, lordship will call for the recourse, but at least at this point of time, my lord, looking into the nature of this case, because all the family members are undergoing treatment. Now, if these persons, my lord, are not given an interim protection, they're presently, my lord, the female members will be left vulnerable.
Such an grievous injury there also. So, call for a case there it is. And being a cross case, also it is not cannot be ground for privilege of pre-arrest bail. So, call for a case there also. Because medical report was there on another trial court, and it reflects that grievous injury was there. Page 23. Rejection order in the London trial court.
Now, earlier, London trial court also granted me an interim protection also on 4/5/20. That was state vacated. Now, during that period, I have thoroughly cooperated with the investigation. Lordship will find it at page number 22 also. Earlier, my lord, we were granted with, 23 also, 23. Interim protection was granted in the very first instance. And nothing in this rejected bail order, my lord, there says that we have not cooperated with the police. We will cooperate. There's nothing in this bail order which has said, my lord, that we have not cooperated with the police or we have hampered or tampered with the evidence.
This case also call for a case along with the jury court also.
When you see FIR, present FIR is on page?
Page number 12, my lord. Sapor PS case number 41/26.
Mr. Committed that he that that the fact that there was a quarrel and tussle took place between two groups, and for which the petitioner side had earlier instituted, lodged an FIR on 16/4/2026 for the Alice incident, which took place on 21/3/2026. The lodging of the FIR by the petitioner side, the informant side also lodged on the very next day, that is on 17/4/2026. The further submitted that it's but further submitted on the day of the incident. The all the informant side had entered into their trespass into their house and brutally assaulted the victims and victims and all the family members of the petitioners. Most of the family members are still under treatment, and when the two injured were taken to the hospital, the accused, the informant side again attacked them, causing grievous injury on the person. However, they are still ready and willing to extend their cooperation in further investigation in this case if they are content with surrender. It's a serious allegation of causing grievous injuries on the victims, and the learned additional session that also rejected the bail prayer of the petitioners, considering the grievous injury sustained by some of the victims. Mr. Goswami accordingly submitted the CDM report along with the injury. During this submission, it and also considering aspects of this. This court is of minutes we provided and petitions still receive instructions. Okay, will be under interim protection CDB obligation to the injury.
10th of June.
10th of
Deeply obliged, ma'am.
Okay. Up-to-date CD was called for, Chief. That we have not received the up-to-date CD was here, Chief, that was not taken back. That's why the updation is not here. This
the
from
call
Golgaon.
for updated one.
Not updated.
Today 65 and 70 days lordship in judicial custody. Well, this is a case lordship. At best, it is, my lord, 105 lordship. Maximum punishment is, my lord, 10 years lordship. So 60 days mandatory lordship, although the case is registered under section 103 lordship. Southern provocation, my lord, the land dispute is there. Title suit, my lord, of the petitioner number 2 lordship is going on lordship. In that case, prayer was, my lord, restraining the respondent, the defendant's lordship, the informant lordship, in this case lordship, and they, my lord, trespass to the petitioner's land, and my lord, and quarrel, sudden quarrel, the group fight was there, lordship. So this is a case 106 under section 105, my lord. At best, my lord, that is matter of trial now. At this stage, prima facie, my lord, from the both the FIR and cross FIR, it is in that the case is, my lord, case established under section 105, lordship. Now 65 days and 70 days in judicial custody,
You
lordship.
have received a case diary to otherwise.
Case diary otherwise received earlier, that also case diary received, lordship. Earlier he was admitted from the AIMS. That report from the AIMS was in the AIMS hospital, lordship. The report from the AIMS was required document that was called for. That report is not received yet. Otherwise, PM report is here, lordship.
What PM report says?
PM report owns coma as a result of head injury from blood force impact, and eyewitness also there.
My lord, for a moment, kindly see page 10, 11, lordship, the FIR.
my lord, he was admitted in my lord AIMS lordship. On the same day, he was, my lord, after having treatment, my lord, he was released, he was found okay, lordship, then released, my lord, discharged, lordship. My lord, had it been, my lord, he had been, my lord, so serious, lordship, my lord, he would not have been, my lord, released on the same day, lordship. Now, thereafter, he went home, lordship. And therein, he was not, my lord, he was unwell, lordship. He was taken to, my lord, civil hospital, local civil hospital, lordship. And therein, my lord, he was, my lord, declared dead, lordship. The plea of the petitioner is that he expired due to subsequent event, lordship. Now, in that case, my lord, the honorable court, lordship, earlier, my lord, directed to produce the, my lord, AIMS certificate, lordship, discharge certificate, injury certificate, lordship. Now, it is not in the, they are in the CD, lordship. Now, my lord, the cross FIR, my lord, in the cross FIR, it is stated that they came to the land of the petitioner's lordship and quarrel was their, lordship. Now, in such a case, my lord, it is other case, in other case, my lord, cross FIR CD was also called for, lordship. That is probably not there, actually. Dolga 47. My lord, that now, may I pray for at this stage, lordship, to grant my lord interim bail, lordship, because my lord, today is 65 days and 70 days, lordship. Now, we may be directed to be released on.
What do you want to submit? He died subsequently for why? Why did he die?
My lord, from the FIR kindly see, lordship. FIR, it is stated, lordship. At page 11, lordship. At page 11, married, lordship. With due respect, I beg to state that on 5/3/2026, at around 12:30 AM, the below mentioned accused persons armed with weapons in a vehicle bearing registration number so and so collectively trespassed into our land and forcibly uprooted the brinjal plants from the field, looking which we resisted, for which the accused persons physically repeatedly beat my father Zamir Ali, wife Mumtaz Begum, brother Moinuddin Ahmed, and nephew Moti Meraz with dowels, dagger, iron rod, and sharp-pointed weapons, and accused all of them, caused all of them grievous injuries in various parts of their persons. As the condition of my father Zamir Ali and wife Mumtaz Begum was critical, police of Dalgaon police station were informed, for which the police rescued the injured persons and took them to Kharupetia hospital. Therefrom, the doctor referred the injured to GMCH, but for better treatment, we admitted my father at AIMS Gauhati. The doctor at AIMS provided treatment and discharged on the same day. On the way back home at around 4:30 PM, my father again suddenly became unwell. We immediately took him to MCS. My lord, why I am submitting, lordship? My lord, AIMS is not a, my lord, that type of hospital. In that, there would be, my lord, negligent in, my lord, treating him, lordship. He was treated, my lord. He was found okay, lordship. He was discharged on the same day, lordship. Had it been, my lord, so serious, lordship, he would not have been, my lord, released, lordship. So, in my humble submission, my lord, as per instruction, my lord, he expired in the subsequent event. On the other hand,
Why he died?
my lord, why, my lord,
Why?
went home, lordship. Thereafter,
Why he died?
my lord, there
You
may
have
be
that
some, my lord, in vehicular, my lord. Subsequent event, my lord, what happened, my lord?
No, what happened?
As per instruction, my lord, there may be, my lord, in the,
Because it is
might
not
be,
the
my
case
lord,
that
some.
after 3 months he died. It's not the case. Then same day he died. Why he died?
My lord, because, my lord, he was taken to my home, lordship.
Why he died? Why he
My
died?
lord, as per instruction, my lord, his subsequent event, lordship,
No, what subsequent event?
my lord, in nature of injury, lordship.
No, what subsequent event? Why he died or how he died?
My lord, might be some accident, lordship.
Oh, accident took place.
Might have been, my lord. No, what times? My lord? My lord,
If any accident took place, bring it.
It is submitted before lordship that he, my lord, died due to coma, lordship. Then, my lord, serious. Why he was not in coma in hospital, lordship?
See, how can you believe the doctors? Obviously,
With the presumption, lordship. I'm not blaming the doctor. My lord, doctor in AIMS cannot be blamed, lordship.
But you have to blame now.
And lordship going
now in the local hospital.
Because he sustained head injury. See,
now what I mean,
injury was there.
Well, apart from that, lordship, this is a case, my lord. No intention is there, lordship. In the affair, my lord, not a single, my lord, word it is that to kill, my lord, They resisted lordship. There was a resistor from this side and that side lordship, and quarrel was there. My lord, in such a case, my lord,
We have to go through the statement of.
He died for that.
my lord, died lordship, this is the, this cannot be denied lordship. Died lordship, now kindly the cross affair lordship.
Accident, just show
My
me the
my lord,
papers.
cross affair, kindly see.
Where the accident took.
For a moment, cross affair, page 34.
Yes, Goswami, anything to say?
Yes, look, then we have to go to the statement of witnesses. Witnesses fully.
You are for the informant?
Witnesses fully implicated the petitioners. They have assaulted the.
These two petitioners.
Yes.
Cross is a, like,
Cross affair may be lordship, but at this stage, going to the statement of the witnesses, he is full, the petitioners are fully implicated by the witnesses. So this is not a fit case for granting bail, lordship.
well, that is
Because I am
why-
saying only
Only
because
on the
aims,
side.
he was admitted to the aims. That's why the report was called for. That's why I'm submitting. But going to the statement of the witnesses, this is not a fit case for granting bail. This petitioner.
my lord, page 34,
Yes,
kindly
for
see.
informant side, do you want to submit anything?
And postmortem report also reveals that
Yes,
hair
yes,
injury.
give the name, want to submit.
I'm objecting.
Hmm.
My father was by them, they attacked suddenly with armed with various weapons. And my father died, my lord, when he was attacked on his my lord head by my lord. They were armed with. Next, my lord, they have repeatedly my lord, saying this gross FIR. This FIR has been lost at the risky one after my lord 3-4 days of registering this FIR. Nothing has lost another FIR.
Okay, then Goswami, you want to call for the, wait for the report from the aims?
Not teacher lordship can dispose it of because aims
No, the
report
court
earlier
bench have
they
made an
they are
observation,
submitting
that's why
that
I'm saying now.
he was
I am supposed to dispose of the matter, but the one observation is made by
yes
the
earlier
court
observation
bench.
was there. The
That's
report
why-
was called for from the aims lordship.
It can be called for, then I wait for the.
Lordship then.
Can you, will you going to, are you going to retain the case diary or it has to be returned?
It may be sent back lordship.
Send back lordship.
Send back.
Updatation is not, is required to lordship. My lord,
An
on-
observation made by the coordinate bench, that's why I thought.
That's
that
why,
better
Lordship,
to
that's
get
why
the case diary.
my lord, in other case lordship, that was my lord disposed of before the honorable justice, my lord, R. Mazumdar, Rakesh Mazumdar lordship. In that case, my lord, the date was fixed on my lord, 26th of 26th of this month, lordship. My lord, that case was, my lord, listed before this, that honorable court, my lord, as per my lord notification, lordship, as was disposed of, my lord. That, in that case also, my lord,
20?
CD in other
26,
case was
right?
called for, lordship.
Huh?
In that case also, my CD was, in other case, my lord, Dolgaon 47, cross case was also called for, lordship.
Dolga means your cross case.
Yes, lordship, Dolgaon 47, that is why page 34, lordship. If you, lordship, go to the, my lord, page 34, cross case, lordship. There is a,
Nothing in the cross.
as it is there, lordship, page 34.
No, there is nothing in the cross case. You have simply lost the FIR.
In that process, his CD was called for not that is.
It was called for, this is order, lordship.
No, it was called for this,
Yes,
case,
sir,
in
it
this
is so.
case. No, in this case.
In this case, my lord, earlier it was
Go
called
to
for, lordship. Kindly see the, my lord, previous order, lordship.
Matagram.
My lord, previous order may be called for, lordship.
Yes,
May be seen, lordship. In this case, particular case,
কি করবেন?
in that case, also, it was on 22, lordship.
Card. এটা দিতে হবে না।
There is a heavy, my lord, one co-accused law submitted.
That was an AB in your cross case.
Yes, lordship. My lord, in this case, lordship, not in cross case, lordship. In this particular FIR, lordship.
Particular FIR,
My lord, this particular FIR, lordship.
not for the cross case.
No, lordship.
Oh, it will make FIR,
Some FIR, lordship.
same FIR. আচ্ছা।
Some FIR. It is stated.
Hey, can you get the report? Or you want to send back? What do you want?
Updated CD. Huh?
26 may not be possible.
26th, my. On 26th, lordship.
26 may not possible. Will come.
possible.
26. Do you think?
It may be sent, if the IO sent.
No. Do you think it will come?
First week of June.
Don't return the case diary.
Lordship.
The regular bail application, my lord.
No, we are not going to return the case diary. Let the report be called for. That can be.
No, it may be returned back, my lord. Update, it is stated that the CD is not updated, lordship,
In that case, you won't get on 26.
my lord. That is why, my lord,
That is
I'm
on first
cognizant
of
we are lost.
June. Let it be on 1st or 2nd of June. You won't get. Updated case diary you won't get by 26. 20,
In that case, my lord, the CD will come, lordship, again. So it may be sent to the Dolgao, lordship. It may be. It will. Otherwise, it may be directed to be listed in along with this heavy lordship.
End of June. Hard so and so.
In other case,
Your good name? M. Ali. M. Ali করে দিব appear for the informant করে দিব থেকে MH Ahmed করে দিব Usami Khat করে দিব is submitted by Mr. Gupta. Proceeded but is not updated one. Specialty report from the aims is not available in the case diary. It was asked by this court by order dated 8/5. Let the report from AIM report injury report from the aims be called for. Return back the case diary with a direction to the IO. One is the same with application along with the injury report to be collected from aims. 1/6. 1st of June.
2nd of June. Oh,
2nd of June. No, 2nd.
2 days, 70 days lost. Send back. Lordship, send back.
Send back the case diary. And you just communicate with the IO to return it back. Otherwise, it will remain in your public.
All of this.
2022, we have not received the case diary.
We have received.
Not received.
Not received.
40 days in custody. So
Your petitioner is in
60 days.
custody since 40 days.
40 days, 60 days.
So 5th of June.
Will be 56 days. Kindly on 1st of June.
You should remind them. With a direction to IO to raise
Lordship, case diary along with the PM report maybe.
yes, case diary along with the
Deeply obliged.
My lord, here, my lord, 41 and 42 also may be taken up, my lord, because arising out of the same CD, my lord.
41 and
41 and 42. Your lordship may first take up, my lord, item number 41, my lord, because some additional documents were annexed with the application, my lord, subsequently, my lord. And there is an additional affidavit also in connection with item number 41, my lord. My lord, before going to the FIR, my lord, here, my lord, 8 person, my lord, name in the FIR, my lord. All are, my lord, relatives. There is a land dispute in between the parties, my lord. And among 8 persons, my lord, 2 persons arrested, my lord. And in item number 30, there is a petitioner Hashmut Ali. He is also arrested along with one Uzir Ali, my lord. That other 4 person now before your lordship with three bail applications, my lord. And other 4 persons approached the learned session judge, my lord. And those persons, my lord, one is BA and one is AB, my lord. That 4 person has been granted bail, my lord. Regular bail as well as anticipatory bail, my lord. By way of
file this your affidavit to bring what thing?
additional affidavit, my lord.
Yes.
That
you
I
want
have
to
to bring the record of the learned court below's order, my lord. Where the
Learned
other
court
4
below-
accused person has been granted bail, my lord.
Only for that.
That, my lord, yes, my lord. Now, my lord, in item number 41, your lordship may kindly see the FIR, my lord, first, my lord, page 19, my lord. My lord, 18, my lord, page. May I read, my lord? এজাহারকারীৰ বিনীত নিবেদন এই যে যোৱা 23/3/2026 তাৰিখে মোৰ বিল্ডিং জেচিবি লগাই ভঙা কেন্দ্ৰ কৰি উপৰোক্ত পদক্ষেপৰ বিৰুদ্ধে আপোনাৰ থানাত এখন এজাহাৰ দাখিল কৰিছিলোঁ। তেতিয়াৰ পৰাই পদক্ষেপে আমাক এজাহাৰখন উঠাই ল'বলৈ দাবী ধমকি দি আহিছে। আমি মানা কৰাত আজি ৰাতিপুৱা প্ৰায় 8মান বজাত পদক্ষেপে হাতে হাতে চোকা অস্ত্ৰ লৈ আমাক ঘৰলৈ খেদি আহি মোক মোৰ পত্নী ৰেজিয়া খাতুন আৰু মা আমেলা খাতুন ভাই বোৱাৰী স্বয়ংসক বেয়াকে মাৰপিট কৰে। ফলত আমি আটায়ে শৰীৰৰ বিভিন্ন অংগত গুৰুতৰ জখম পাওঁ। ইমানতে ক্ষান্ত নাথাকি পদক্ষেপে মোৰ পত্নীৰ পিন্ধি থকা কাপোৰখন টানি ফালি আৰু ব্যক্তিগত অংগত চুই শালীনতা ভংগ কৰে। On the next page, in the next page, my lord, লগে লগে আমি আটায়ে হাজ এফআৰইউ চিকিৎসাৰ বাবে অহাত ঘৰত কোনো নথকাৰ সুযোগত পদকীয়াগণে আমাৰ ঘৰত জুই জ্বলাই দিয়ে। উল্লেখ থাকিল যে পদকীয়াগণে মোক মটৰচাইকেল স্বয়ংসখন ভাঙি চুৰমাৰ কৰে। That is the FIR, my lord, and the date of the FIR, my lord, page 18, 21/4/2026, my lord. This is filed by the Salam Ali, my lord, who is the nephew of the petitioners, my lord. Their elder brother's son, my lord. And my lord, now, my lord, kindly see, my lord, the first FIR, which was filed by the same informant, my lord, that is on, my lord, page 20, my lord. 29 is the vernacular, my lord. May I read, my lord? 29, my lord. It is lost earlier, my lord. Here, my lord, after registration of the case, the informant found all the sections are available, my lord. That's why after 1 month, 21/4, they lost the second FIR, which I seeking pre-arrest bail, my lord. The first FIR is, my lord, page 29, my lord. Kindly see, my lord. Date
What
of,
about the first FIR now? Is there any investigation?
my lord.
For the first FIR, is there any investigation?
Yes, you know, registered, my lord, investigation run, my lord. After investigation, the police registered the case after bailable sections, my lord, registered case. After
You are saying that page number 29 is the first FIR.
first FIR, filed by the same informant, my lord, Salam Ali, my lord, who is the nephew of the petitioners, my lord. Their elder brother's son, my lord. That FIR registered, my lord, page 29, my lord. May I read, my lord?
One thing here I am to clear, Lordship, I have received a case diary in item number 41. Here, petitioner is an interim, but their statement is not in the case diary because they are not in time 14/5/2026.
They have appeared, my lord, as per my instruction.
DD was 8/5/26 up to date on. Their statement is not in here, but clearing this.
What about 42?
41. 41.
In 41, and
41,
42. 42, the interim was not there. 42,
42, all are interim there, my lord. 41 and 42 interim.
Their statement is here.
in 42.
42 statement is here.
They are all brothers, my lord. They subsequently, item number 41, my lord, subsequently granted interim bail, my lord, because they filed subsequently, my lord.
42
Anticipatory bail. Now, my lord, your lordship, kindly see the first FIR, page 29, my lord.
40,
The same informant, my lord, Salam Ali.
yes, it was on 34.
Okay.
It was on 34.
My lord, subsequently, my lord.
That's why the statements are available.
Yes.
Whether any order is also not available.
Not
The CD is last entry is 85.
85.
Let's come to 42. What is the let us don't forget of 41, 42.
42
their
not-
statements are there.
42 Lordship,
Ismat
Ismat Ali, his statement is here. Here appear.
Ismat.
Ismat, my lord.
And the rest is what is the materials in the case diary.
Materials regarding injury, yet we have not found the injury report here, Lordship. Otherwise, some photographs are here. The allegations are so burn fire the houses also, Lordship. Some photographs of burning materials are here. Otherwise, witnesses are stating that they have said by the complainant that they have made fire in our house.
My lord, regarding
But physical assault part is going to the injury report is not here.
Is there any list what kind of these materials were burnt or any destroyed?
Not least. My lord, as per my instruction, no injury is there. That's why, my lord, the section charged here of regarding assault, my lord, it's all are bailable sections, my lord. And my lord, if your lordship go through the additional affidavit, my lord, the learned court below's order, here it is specifically mentioned details, my lord, in the additional affidavit, my lord. The other 4 accused, my lord, they have approached in the learned trial court. One is bail application and another is anticipatory bail application. These
No
two
list,
applications has been disposed of, my
No
lord,
list.
granting bail, my lord. Kindly see the, my lord, the additional affidavit.
40. 40. One. Yes, it's our submitted statements that petitioners were on interim protection, but their statements are not available in the case diary, as the last entry of the case diary is of 8/5. Accordingly, submitted the case diary will be followed. If the statement of the it means the statement of the accused petitioners were already recorded by the next Mr. Mullah that they for their instruction they appear in their statements were recorded by the in view of this, let the CDB returned and call for a updated one with the direction to the I. One is the updated case diary along with the statement of the youth petition if already recorded, and further if the statements are not yet recorded, comma, the petitioners are hereby directed to appear before the I within 7 days of forum to record their statements. CDB returned. Okay, the announced one IO is accordingly directed. Take back the case diary and one is it. This statement 8.8 6. So it's next 42. 42. It the submitted have already appeared before the I, meaning the order of split. Their cooperation verdicts. But stated that the initially the same informant had executed FIR against the present petition, but as it was available of subsequently in the FIR is not inserting some non-bailable sections. It is purely which rules for a land dispute and which falls and forms petition. Here, however, they have appeared here, but still they can be to extend their cooperation in further investigations. State injury is that so it's not in against the accused petition which is involved in considering the submission is the arrest bill. Accordingly, the order of interim pre-arrest bill dated 30/04/26 is hereby same dispose of one
Item number 30, my lord.
186 with the
Yes, sir.
item number 30. Yes, item number 30, what do you want to submit, Mr. Reddy?
Item
Yes.
number 30, my lord. There are, your lordship may kindly see the forwarding report, my lord.
The forwarding report is leave about forwarding report since when they are in custody?
Till, my lord, 23 for 28 days, my lord. My lord, in forwarding report, they along with the petitioner one and another person was arrested, my lord. That, my lord, page 20, my lord. Name and address of accused person, Hashmat Ali petitioner before your lordship, my lord. And another Uzir Ali, my lord. That Uzir Ali has been granted bail by the learned court below, my lord. I have annexed.
Yes, it is stated Uzir Ziaru, their family, the dispute between landlord, both the families. It is stated Uzir Ziaru hote, কিছু মাটি বাইলো সালামাতলৰ কাজিয়া কৰি থাকে and Uzir Ziaure my ঘৰ তুই লগাই দিয়ে বুলি সালামে কয় বুলি that part of the witnesses stated. So here witness going to the statement of the witnesses, Hashmat Ali's name is not reflected in the part of the case. He is a member of the family, that's why his name is here.
Petitioner is not PLS documents. However, it is the fact that there was a land dispute between the parties and some scuffle and altercation took place. That apart, there was no such incident as there is in the part submitted initially when FIR was lost by the same informant with some informant wherein the sections registered are available, which after about 1 month later, he lost another FIR with some incorporating some non-billable parts. However, the present petitioner is in custody since 23/4/2026. Thus, the RO got sufficient opportunity to interrogate him. Some that from the vendor statement, the case diary, there is no election against the present petitioner in setting fire at the house of the informant, and injury reports are also not available. The case we submitted that some information are there against the present petitioners. Considering the submission made by methods in the case diary and the length of detention already undergone by the accused petitioner. This court is of opinion that IO got sufficient opportunity to interrogate him, keeping him in custody, and hence further custodial interrogation may not be necessary for purpose of investigation. It is for whose satisfaction?
Judicial magistrate first class, my lord. Hajo.
Judicial magistrate first class.
My lord. Okay. Your lordship dispose of item number 30 and 42, my lord.
The same incident, one by wife of the deceased, and subsequently another the mother of the deceased. In the 40 affairs, 2 sets of accused persons have been named in the affairs, but these petitioners were not named in the affair, neither in the first nor in the second. But it is submitted away from the transit also, it is seen that there is no specific role attributed by the accused petitioner, which reveals by the accused petitioner to implicate them in the presence. They were not aware about the balance of this case, nor during the entire investigation, police ever charged for him or them. All the accused petitioners are the same family members, and they were falsely implicated in this case without their involvement. If I suspected that one of the co-accused already been granted with pre-arrest bail by ordinary bench of this court, However, the petitions are willing to contest the case by appealing to the London Court below. That's where it is fixed. Next, Mr. Tilanet counsel appealing from submitted in this regard. That one in there is another case is pending against the present petitioners along with the victim of the deceased, and when the deceased got bail, the the present petitioner of the petition, he managed to came out from the post. Thereafter they made a conspiracy and they he designed and manipulated conspiracy and killed the victim by assaulting brutally by all the accused persons, including present petitioners. He accordingly submitted one session case number 36 2023 arising out of Gauripur PS case number 3 of 2023 is pending where against the present petition, and thus is seen that there are earlier criminal there seen that there are criminal antecedent against the present petition. So Mr. in the raised payment that it is to privilege of rearrest pay to the present petitions. Next, Mr. Tiganek the present petitioner never cooperated with the investigation and they were absconding and avoiding the arrest during the investigation, which they could not be apprehended by police in spite of their testimonies. He further submitted that two eyewitnesses specifically mentioned about these three accused petitioners, and one of the eyewitnesses has also given his statement under section 183 BNCs. From the statement made by the eyewitnesses, three of the eyewitnesses it reveals that they are specifically identifying these accused persons who accused petitioners along with the others who brutally assaulted the victim with sharp object and committed. Next, Mr. Sharma further submitted that the order of the honorable court and bench was in connection with the eyewitness, in connection with the accused petitioner. It reveals that there is no eyewitness for the same accused person. The accused person, and the submission was and he was treated on the basis of a statement of made by co-accused, and accordingly considering those aspects of the case, the bail, pre-arrest bail or the co-accused was considered by the learned court. In that context, he also cited a decision role of commands arising out of assembly in 431 source. Wherein also it is been observed by the honorable scope that clarity is not the wrong for granting bail. The court is to see the role played by the accused petition. Privilege of pre-arrest bail to the petition. He further submitted that initially the summonses were issued to the present petitioners, but in spite of recipients, they did appear before the NBWA is issued at considering this. And here, we see that the case has been charge sheet showing the present petitioners as absconded along with some statement made in the charge sheet as well as the statement of the eyewitnesses, including the statement of witness under recorded section 1 PNSS. It is seen that these three petitions are specifically identified and specified, identified and they specifically mention about them as to how they brutally assaulted the victim. Further, it is seen that on the note of the file, during investigation, present petitioners never cooperated in the investigation of this case, and for which they have to be shown as an absconder in the case. Further, considering the submission made by Mr. Shakti Learned Petitioner PP, it is seen that ground of clarity may not be applicable in all cases where the role played by the present petitioners are specifically mentioned by the witnesses. However, without going further detail into the merit of the case, this court is of opinion that while some interim protection may be provided to the petition to some represent with the direction to appear before the learned trial court below with a regular bail application, which may be considered in accordance with law, and the NBWA issued against the present petitioner may be kept in abeyance for 15 days from the date of the above observation. The present case is dismissed. We are not granting you any pre-arrest bail. However, some interim protection is provided to you for 15 days. It's not a case of pre-arrest. During the entire investigation, you were avoiding the cooperation, and now you are here before this court. Cannot be. Disposed.
Their lordship, CD has not been received.
Oh, the PO.
Lordship, second time she did not receive. We are not an interim lordship from Kamalpur lordship. Today is second time lordship.
We have reported received case diary here.
CD not received, lordship.
Not received.
Not received, lordship.
You are not on interim also.
No, no lordship. From Kamalpur lordship.
From Kamalpur.
Yes.
Next week we don't have any date.
Okay.
Next week we don't have any date. Already over. Come for the 22nd. 22nd. Still forward. What's up? The purpose. One, I mean, I'm doing suppose hearing to my to well. You're hearing to for it time. I think he will come.
No,
What kind of possible number forward to the copy support? People coming good one, getting quick one time lot. So the time lot of part with the getting quick with so it can't put up side. Mane from 30 to break with a go by. You can't put on যদি নহল তো বাকি তো ওপর হলেও তো কারণ নহলে 75 সব দুইটাই হয়ে যাবে আজকে বহুত বেশি যেভাবে হয়ে যাবে
Lordship, we will be putting plus victim committed suicide in her home lordship.
No, no,
Same
we
minor.
not first day it was not granted. We are not granting. Now, why SCD is not here?
Lordship, we have no any communication. We have sent the signal. Lordship will fix it on the next day. I will ensure, Lordship, the CD will produce.
And based on first of the next week, we don't have any.
Lordship.
There are some reservation on the next day.
Lordship, we can second or otherwise I will look at there in first, then lordship.
First, you may
I'll
not be
out,
there.
I'll out, do outside.
Second will do.
Yes, sir.
Issue reminder with a direction to the I to furnish the case diary on or before the next date of listing. In default, he may be served with a personal show cause notice. He may be served with a personal show cause. This is the matter on second. Otherwise, he will be served with a personal
Yes,
show cause notice. We are listing it on second.
Second of obligation.
Yes, what is 37, 38?
Yes, they received.
CD already received.
Yes, lordship.
This is our same FIR, na? Oh,
Lordship.
for the same accused.
Yes.
Not from the FIR. No, no,
Lord-
not from the same FIR, but from the same accused.
Same FIR lordship. This 37 is for one person and 38 is for 4 persons.
The allegation.
For accused.
For Farooq, Farooq Ahmed.
Yes, lordship. In 38 lordship, one juvenile is there. There is interim for the juvenile lordship. Lordship, I'm on 37 lordship.
37.
FIR lordship. FIR is at page 13.
Hmm.
What is alleged in the FIR lordship? Just 5-6 line there on the first paragraph lordship. This this informant's son, aged about 17 years, went to take bath in the pond of this petitioner, lordship, item number 37. This pond was usually used by all the villagers, including the family of the informant also. They used to take water from them and also take bath in that particular pond, lordship. It was on the roadside pond. Its boundary wall is also there, and there was pakka guard wall on both sides of the pond, lordship. So what is alleged in the FIR that when his son went to take bath in the said pond, at that time the accused number 1 to 4 were constructing a permanent house on the bank of the said pond of Hilal Ahmed, the brother of the accused number 5. It was alleged that the 1 to 4, that is the accused in the other case, 38 lordship, they were 1 and 3 were mason and 2 and 4 are labor, jugali, with the mason. So it is stated that they were busy in construction of a house of the brother of the accused number 5, that is brother of the petitioner of this 37 lordship, Farooq. Not with the Farooq, but with Hilal's house they have constructed. Hilal is the brother of Farooq. It is their case. Therefore, he has been creating various obstacles to prevent me and my family member from bathing in the said pond. It is alleged that the accused number 5, that is the present petitioner Farooq, had been obstructing their family in taking bath in the pond, which belongs to this Farooq. Then, lordship, it says that my son goes to bath in the pond. Accused number 1 to 4 often misbehave with him on 15 to 26 at the instigation of accused number 5. That is the allegation, lordship. 15 to 26 at the instigation of accused number 5, an altercation took place between my son and accused 1 to 4 on the bank of the pond. When my son was late in returning home, he came that when the son was late in returning home, after bathing, I went to the pond in search of him, and not finding him, I inquired with accused number 1 to 4 who were nearby, but they did not give any proper answer. At that time, while I was searching, neighbor one Yasmina Begum asked me to search in the pond. I went down in the pond water, searched my son, and found him dead under the water and brought him up to the bank of the pond. And thereafter, lordship, it is also stated that currently, then the postmortem was done on the next day on 16 to 26. After the postmortem, when the dead body was handed over to me, I performed his last rites. Currently, based on the conversation of the accused persons, I have a strong belief that due to my dispute with the accused number 5, that is Farooq, accused number 1 to 4, in conspiracy with the accused number 5, assaulted and murdered my son and threw him into the pond. It is his suspect that as because he had strained relationship with Farooq, Therefore, in on the instigation of Farooq, the other accused persons, that is of the item number 38(1), this petitioner number 1 to 4, they assaulted his son. That is his allegation, Lordship. Now, Lordship, I would like to place, of course, it might be in the CD, Lordship. It might be in the CD. On the date of the alleged drowning, it was a case of drowning, Lordship. On the date of the alleged drowning, this informant had filed a written intimation to the police, Salsapra police, Lordship, and thereafter, I have already mentioned in my petition, Lordship. Thereafter, UD case is registered, and UD case number 14/26 is registered, Lordship. It is pleaded in my petition. I could not obtain the copy. Only this 2 days back, I have obtained the certified copy, Lordship. I would like to read out, if Lordship permits, what has been written by the father, the informant, on that very day. Sir, বিনীত নিবেদন এই যে আমি শ্রীকোনা দ্বিতীয় খণ্ড বরাকের গ্রামের একজন স্থায়ী বাসিন্দা বটে। বিগত 15/2/26 তারিখে বিয়লি 3:30 ঘটিকার সময় আমার ছেলে স্নান করিতে গিয়া পুকুরে পড়ে মারা যান। মৃত্যুকালে তাহার বয়স হয়েছিল 17 বছর। তাই আমি আমার জ্ঞান বিশ্বাস মতে আমার ছেলে পুকুরে পড়ে জলে ডুবে মারা গিয়াছে। That is Aulad Hussain, the informant of this case, Lordship. That is on this basis, the UD case number, this 14/26, was registered, Lordship. And thereafter, on 23/3/26, therefore, what happened, Lordship? My case is that, as per instruction, my case is that, as because the son of the informant died by drowning in my pond, I was busy 1 kilometer away in my pharmacy when I got information from the neighbor over telephone that something happened in your this locality, and some boy has been died of drowning. So I came to my house and saw that on the bank of the pond, this body of the boy was being recovered, and thereafter he was taken to hospital, and then he was cremated. And then what happened? The informant claimed a heavy compensation from me, from Farooq. When I refused to give compensation, because I was not there, his son died due to this drowning while he take a bath in the pond. So I refused. Then after 1 month, 8 days, that is on 23/3/26, this FIR is lost. After 1 month, 8 days, this FIR is lost by suspecting that we may be involved in the death of his son. Lordship, at this stage, what my humble submission is that I can't say what is in the CD, but I have to point out before this court that whatever is written by on the FIR by this Abdul Hussain, the informant, he and his family may say that they suspect this Farooq and others. But I have a strong belief that nobody can see any incident of assaulting his son by any of the accused persons which this leads to a death of his son. And that apart, I have instruction that the deceased died of drowning, and I have instruction that the doctor has also given postmortem report that he is of drowning, and he has also stated in his FIR that there was some swelling injuries on the body of the deceased. That maybe they are, Lordship, because the pond is having pakka guard wall on both sides, and while with this bathing, he may take this soap, and thereby he may this heat on the guardrail also. That may be there, but so far as our involvement is concerned, we are in no way involved in this particular case. Therefore, we are local men. We will stand trial. We will cooperate with the investigating agency. This anticipatory bail may be granted. And in respect of this item number 38, Lordship, same is the case, Lordship. In item number 38, 1 and 3 are mason. They are very poor men, and 2 and 4 are labor who are jugali with that mason. Lordship, in respect, the petitioner number 2, Nazir Hussain, he is a juvenile, Lordship, and on the basis of this birth certificate, your Lordship was pleased to grant interim protection to him, and accordingly, he went to the police station, police had recorded this statement, his statement, and he was allowed bail, Lordship, as bail. And that is the position. And one thing is that, as because they have said that we are, these 4 are working in the brother's house of the accused Farooq. But our contention is that for last 3 days of the date of occurrence, that is 15 to 2, Lordship, the construction work was being stopped due to non-availability of some building materials. The cement and other materials were not there. Therefore, they are also not working at that particular moment, at that particular time in the house of the brother of Farooq. And they are not working under under Farooq. They are not working the construction work of Farooq. Rather, they are working the construction work of the brother of Farooq. And at that particular moment, for about 3 days, there was no work. So they were not present also. This whole allegations of this suspect, whole allegation of suspect is are false, Lordship. And we are very poor people, and they are the only earning member of their family, Lordship. These 4 persons. So I may be given protection, Lordship.
If I may just submit, Lordship, here, Lordship, the post-mortem was done. It is a case of drowning, Lordship, anti-mortem drowning. And there are several injuries, Lordship. Those injuries are not, Lordship, as per the IO's note, Lordship. He has done a detailed investigation of the site, Lordship. There, Lordship, what he has found is, Lordship, that the pond, it is covered by cemented walls. And, Lordship, there are 3 steps going into the pond. 2 are not visible, Lordship, from the ground, Lordship. 2 steps are not visible. Now, Lordship, there is a detailed report, Lordship. He has made a thorough investigation, Lordship. There he has found, Lordship, it is a case, Lordship, that where the person, Lordship, the deceased, Lordship, he applied soap on his body and he just jumped on the, and thereby he had some injuries in his body. And the injuries that had been found in the forehead and side of hand and face, Lordship, all those are injuries which are caused when one person is, Lordship, rubbed on the wall or something like that, Lordship. Abrasion type, Lordship. It is not a handmade injury, Lordship. If Lordship kindly goes through the note of the IO, Lordship, it will be clear, Lordship. So the IO in its statement has stated that there is no foul play, Lordship, as such. Thank you.
Part three. 37. 37. Study and constitutional. Next one. Mr. Udari and petition submitted in that the FIR will not with some false and component allegations against the present petition along with some others. It further stated that during the time of incident, the other accused persons who are working as a stated to be working as a mission and labored were working in the house of the brother of the accused persons, but during that time of incident, the construction work was stopped and he has no connection with the and there is no such and connection was stopped. But he submitted that a pond wherein the unfortunate incident had happened is a public one wherein some villagers also used to take part, including the family members. On the day of incident, accidentally a deceased fell down in the pond and died only due to drowning. And on the same day of incident, the father of the deceased, that is the informant, and lost the information. No, gave information before the police station regarding the drowning of death of his son due to drowning, and on the basis of which one UD case has also been raised and investigated. But thereafter, the petitioner demanded some money, demanded compensation to the present petitioner, stating that he, being the owner of the pond, has to give some compensation. As the petitioner refused to give such compensation, the informant, after 1 month, 8 days of the occurrence, had launched the FIR with the false allegation of murder of his son. And accordingly, it is submitted from the submitted that the actual that the deceased died as when he went to take part in the seed pond accident, and as accidentally fell down and died due to drowning. However, the present petitioner is ready and willing to extend his cooperation in the further investigation of this case if he is granted with the privilege of pre-arrest. Next, Mr. Sharma, the non-additional briefing submitted in this week. That as per PM report and the as per the eyewitnesses, the deceased died out of drowning, and the injury marks which were found on the body of the deceased were only due to only for the dashing against some rough surfaces, as there was a guard wall around the pond. He further submitted that a detailed inquiry was done by the investigating officer, wherefrom also it is very specifically mentioned as to how the deceased slipped while he was taking part and died due to drowning. More so, the injury which has sustained by the accused, deceased, cannot be the ground of his death, and it is exclusively for the drowning. Next part, considering the submission made by London Council for materials available in the case diary, vis-a-vis the inquiry report of the investigating officer, this court is of that actually interrogation may not be necessary for the purpose of investigation. Accordingly, I find it difficult to extend the privilege of pre-arrest bail to the present petitioner. So there are some 38 o'clock, same technical Shorter submission came allocated on paper submission that submitted that the accused petitioners were working as a mason and laborer in the construction work of the brother of the accused number 5. But at the relevant time of incident, the construction work was stopped and there was no construction work was going on in the house of the brother of the accused. These petitioners are not at all involved in the alleged offense. And it was purely an accidental death where the deceased fell down on the pond, in the pond, accidentally and died. Thank you.
Two may be made
Accused
absolute.
petitioner number 2 would probably, he was the accused petitioner
But
number
if
2.
two may be made absolute in time order.
Who আছে you may absolute কৰিব accused
One,
petitioner
three, four may be allowed.
made absolute কৰিব আৰু বাকিখিনি ক্লিয়াৰ কৰি দিব। Two of the intimate day of the because of his juvenility. Okay, both demands.
Apply this.
May I please the lordship? Very sorry, lordship. In item number 47, your lordship.
Huh?
In office note says item number 47, your lordship.
40?
47.
47.
Yes, your lordship. In this case, what happened in the office note, it is said that a scan copy is not received, your lordship.
Huh?
So when I take inquiry in the
You want to bring this scan copy?
Yes, your
No,
lordship.
cannot be this. How can? Now it is already approved. There are many
Lordship,
matters.
So, your lordship, date may be given in the next week, your lordship.
Seat which? Seat.
Much obliged.
Present criminal revision petition stands rejected and the order passed by the learned appellate court is hereby affirmed.
Deeply over.
All right. Do not find it a fit case for Quashing and accordingly the present criminal petition stands dismissed.
Highly applies. Highly applies, my lord.
Lordship, with due respect, Lordship, item number 15, Lordship, admission order. Other party is here, Lordship. The respondent counsel, Mr. A.K. Huya, has some difficulties, Lordship, so I pray to fix the matter after 2 weeks.
Item number 15.
15, 1-5.
So you are for the
Respondent, Lordship.
respondent. Mr. Bhuya is support.
Yes, Lordship.
Yes, who are for the, you
I'm,
are for,
I'm for the petitioner now.
Tiwari, I saw you, you're sitting there, no?
Yes, madam.
Okay then, was there any entry?
Yes, madam.
Part Mr. A. Tiwari, on petition. MS entered for the response, and it is submitted that the NBS counsel, Mr. A. Bhuya, has some personal confidence to it's Mr. Tiwari is position. Let the matter be accordingly listed. Hearing date. They better fix it on hearing date.
It can be admitted and fixed for hearing, my lord, because now the PCR also arrived. my
No,
lord.
Lordship, we'll fix for admission column, Lordship.
Let it be,
Let us
whichever,
be in
whichever.
admission column.
Yes, sir.
It may be
Sure.
disposed of in admission column itself, no issue. Middle of June. Mid of June will do?
Month.
Mid of June. 11th of June.
Deeply obliged.
Obliged.
Interim be continued.
Lordship, with regard to item number 43, Lordship, order
Item
matter,
number?
Lordship. Lordship, the notice upon respondent number 2 is yet to come, Lordship, acknowledgement. So matter may be listed after 2, 3.
Item number you are saying?
Item number 43 on Lordship, order matters, Lordship. Notice upon respondent
43.
number 2 is yet to come, Lordship. Service has been completed, Lordship.
Notice on the respond number 2 is still awaited.
Yes, awaited. We have taken steps, it's still awaited. So matter may be listed after 2 weeks.
Yep. It's submitted that for rest of the service is still awaited for response. In view of this, let the matter be accordingly listed. When you want at the mid of June or
Beginning of June, Lordship.
beginning?
Any day?
Almost full. Beginning is almost full.
Lordship, any date, then second
8,
week
9,
of June,
10, okay.
Lordship,
Six.
obliged.
My lord, in item number 15, my lord, there was an interim order.
Yes, we have already got.
Obliged, obliged.
Oh, 0. Previously. Yes,
Item
what is it? AP 40, sorry, okay, item 40.
May it please your lordship? There was a CD was
CD.
called.
Yes,
The petitioner begs to submit that the Azahar was dated on 23rd. Prior to that, on 22nd, the incident took place as it was recorded there. But your lordship, the employee and his son, who was working there as a distributor of the gas agency, they used to carry the cylinders in their vehicle and distribute to the respective
your
places.
petitioner is a distributor.
No,
Delivery boys.
delivery
Delivery
boy.
boy.
Yes. So prior to that incident, 2 days before, due to the illness of his wife, he asked for salary. Last 3 months, the salary was pending. And when he asked for the salary, he delayed, the owner of that agency delayed the issue and said he will look it out or sort it out some other day. But as it was a serious matter, he has to rush to home along with his son, and behind this whole thing was been framed and constructed to make him.
Otherwise, it is a basically case of theft or what?
Yes, FIR was on
13
page number 13.
1-3.
And
Next
1, page number 13.
So as per the gas cylinder, 19 numbers, empty 47 numbers, and battery 1 number, and cash of
And cash of 55,000.
That has been
It's totally
placed.
fabricated, ma'am.
Your
lordship, actually, this happens earlier also in the this job distribution company, that whenever somebody asks for salary,
your petitioner, who is your petitioner name? Your petitioner's name is?
Fakhruddin, Ritik and Farooq. Farooq is a minor who is under 17. He is the second son. He doesn't even work in the cases.
The name is wrongly.
Here the name is also wrongly written. His birth certificate is also attached in annexer 3,
Page 19.
page number 19.
Farooq is not here. As per birth certificate said, Rich Ahmed.
Yes.
Rick Ahmed or Rich Ahmed, whatever, I don't know. His name is there only. Now, as per FR1, Farooq Ahmed is there.
Yes.
Yes, this name has been wrongly written here.
Normally.
His birth certificate is also attached in annexer 3. Who is
So we
not even
have
attained the
anything
majority.
from where we are saying, except the birth certificate, do you have any other document in the name of Farooq?
No.
Then how can we say, because the birth certificate is in the name of one Rick Ahmed or Rich Ahmed, whatever, I don't know. It is there. And wherein the Fakhruddin. Yes, Fakhruddin is the father. Shown to be father, but whether he is or his brother, that I don't know. Anyway, you are saying that the false case is lost?
Yes, yes.
As he was seeking, asking for salary
Yes.
by this Fakhruddin, accused
Yes.
number 1.
Yes, your lordship.
And what do you want to say in regards to those the items which have been alleged to have been stolen or committing theft?
Not.
On those, in regards to those items?
Let the finding be done, because if the things have been stolen, it could be recovered from his home or his premises or his, but the vehicle itself, it is not in the go down. And more precisely, there was a CCTV camera also. And if the investigation takes properly, the things will come out for the time being. So if you allow the bail in strict conditions, they will comply with all the conditions which has been imposed on.
Yes, Lordship, here, Lordship has seen the FIR. The actual story is, Lordship, these 3 petitioners, Lordship, they are the delivery agent and also the caretaker of the godown. And they reside in the godown itself, Lordship. Thereafter, Lordship, for over a period of time, Lordship, the empty cylinders, they are selling of the cylinders, Lordship, one by one. Daily 2 or 3 numbers of cylinders are being sold off by them. And while they are doing it, Lordship, these CCTV cameras are switched off for that particular time. Now, Lordship, after a few days, after a lapse of time, Lordship, the accountant of the gas agency, Lordship, when he did the audit, Lordship, thereafter he found the deficiency in the number of cylinders. He did not tell you in the books. Then they were charged, Lordship. And there, Lordship, they admitted to the same. And they said, Lordship, specifically this Fakhruddin Ahmed, he stated that, yes, I'm guilty of it. So the amount I will reimburse, you cut it from my salary. Then they thought, okay, we'll cut it from his salary. But thereafter, Lordship, on that day itself, in the night, they stole away 50,000 from the cash and fled away, Lordship. That is the case. And to that effect, Lordship, statement of other employees, the accountant, that is in the case, Lordship. That is the case. And numbers of cylinders, Lordship, 47 numbers, cash 55,000. No, better yet. That is the case.
The lordship is totally false and fabricated. Just because asking of salary, the issue raised up. And if the proper investigation takes place, the things will come out.
They are all their family members.
Yes. Number 1 is the father. Both of them are sons.
And the third one, which is written here as a Farooq Ahmed, his name is wrongly written here. And
now, sir,
his
that's what
son-
I'm saying. You are saying that he is a juvenile. So we want to compare it. But the birth certificate says a different way. So how can we? It's not nothing is there before us that he is a juvenile. Otherwise, definitely there would have been a reason for granting pre-arrest. But Those two are sons.
Yes, yes.
If
Three.
they are against them, what are the other allegations?
Again, three of them, Lordship.
Oh, acha, they are all involved.
They are all together, Lordship. They are doing this together, Lordship.
You are Mr.
M. Islam.
M. Heard Mr. M. Islam, the learned counsel for the petitioner, and also heard Mr. B. Sharma, the learned PPF on the state Senate petition and sit-in Swenson, punishing with Swenson, city receipt. It's submitted by Mr. Islam that the present petitioners are himself, and the petition number 2 and 3 are the sons of the petition number 1, and petition number 3 is still a juvenile. If further submitted, the accused petition number 1 was works as a delivery boy in the said institution. But for 3 months, the owner of the said case agency did not pay him the salary. And when he asked for them, it was told that it will be given within short period. But till the time of lodging of the FI, a salary was not given, and for which, for the illness of his wife, he had to leave along with the other petition. Only with that grudge, the FI has been lodged with some false and concocted allegations. Though nothing has been, though they have not committed any theft in the said case. However, all the petitioners are ready and willing to extend their cooperation in further investigation of this case if they are granted with privilege of clearance. To substantiate the plea that the accused petitioner number 3 is the juvenile, one birth certificate is also next along with the petition. Next, Mr. Sharma, the learned petition people submitted in this regard. As these 3 petitioners are involved in the alleged offense, and all of them were staying in the godown of the said case agency as a caretaker. On every day, they used to sell 2/3 numbers of cylinder, and while committing the theft or selling the cylinder, they used to switch off the CCTV cameras and CCTV cameras. Thus, but post of when the account we can audit, it was then only it was came to knowledge that there is a shortage of 19 numbers of cylinder, and 47 numbers of empty cylinders are missing from the godown. When the matter was inquired about, all 3 petitioners fled away from the godown by taking 55 rupees, 55,000 cash. 55. Post of it is submitted that there are several 5 witnesses who also corroborated the case of the prosecution, and accordingly he submitted that the is not at all the case to extend the privilege of the industry. Hearing this submission made by learned counsel for Proceedings, I have also felt is the diary. It is the petition has taken place that accused petitioner number 3 is a juvenile, and to substantiate the same, one birth certificate is also annexed along with the petition. But surprisingly, the name which is shown in the birth certificate is someone is not in the name of the present petitioner number 3, but it is in the name of one RICH. Though the name of father is stated to be Faruquddin. Thus, there is no such document to hold that the accused petition number 3 is juvenile at the time of lodging. Further, considering the materials available in the case diary and the modus operandi of the case as to how whereby they used to sale the cylinder 2/3 three numbers in a day, and thus committing theft in the said godown for since a long period, where they were entrusted as a caretaker of the said godown by the assets. So considering this aspect of the case, this court is of opinion that anticipatory bail for the present petitioner is not justified at this stage, and hence declared for the dispute stands. Your petition stands rejected.
May I please, Lordship? Lordship, kindly after some time, Lordship. After some time, Lordship.
Sometime to I cannot say because now your
Lordship,
we
senior
will
counsel
start
is.
taking admission matter. So
Lordship,
it may not reach also. Why you sometime?
Lordship, senior counsel is code number 1, Lordship. Last item is going on there.
No, we cannot wait for again. Anyway, keep it. Mr. Tapadar, you are here for the informant.
Lordship, then kindly allow me
The
to.
last occasion also you prayed time.
Yesterday.
Lordship,
Last occasion also.
no, Lordship, the matter.
Written objection to accept.
Yes.
Written objection to accept.
Yesterday listed.
Okay, let's see. If it reaches, then we'll go take up.
Lordship, otherwise I may allow to.
Huh?
I'm ready to move. Lordship. Otherwise, if time.
Or let him submit.
You are going to move. Okay. Yes.
Maybe. Lordship, FIR is that Lordship pays 15, Lordship. Lordship. Basically, Lordship, the merit, Lordship. সন্মান সহকাৰে আপোনাক জনাও যে প্ৰায় 1 বছৰ পূৰ্বৰ পৰাই 1 নং পদকীয়াজনী স্বামীৰ ঘৰ সংসাৰ নষ্ট কৰি আহি মোৰ সৰু ভাইটি জহিৰুল ইছলাম 30 বছৰ লগত বিয়া বহাৰ প্ৰলোভনেৰে নানা কায়দা কৌশল কৰি ভয় ভীতি দেখুৱাই 2 লাখ টকা দাবী কৰে যদিও মোৰ ভাইটিয়ে ভয়তে 1 লাখ টকা দিবলৈ বাধ্য হয় আৰু বাকি 1 লাখ টকাৰ কাৰণে নানা কৌশলেৰে উক্ত টকাৰ কাৰণে হেঁচা প্ৰয়োগ কৰে আৰু উক্ত টকা দিব নোৱাৰাত মোৰ ভাইটিয়ে বিয়াৰ প্ৰস্তাৱ দিয়ে যদিও প্ৰস্তাৱ অমান্য কৰি 1 নং পদকীয়াজনী বাকি পদকীয়াক লগত লৈ যোৱাকালি 23/3/2026 তাৰিখত সন্ধিয়া অনুমান 9:30 মান বজাত কাজাইকাটা স্বাৰ্থখণ্ডৰ গাঁৱৰ ৰমজান আলীৰ ঘৰৰ ওচৰত খাপ পাতি বহি থাকে ঠিক সেই সময়ত মোৰ ভাইটি বজাৰৰ পৰা ঘৰলৈ আহি থকাত পদকীয়াগণে আগুৰি ধৰি লাঠিৰে কোবাই শৰীৰৰ বিভিন্ন ঠাইত গুৰুতৰভাৱে জখম কৰে আৰু বাও হাতখন ভাঙি যায় আৰু লগত থকা 30,000 টকা মোবাইল এটিএম ডিএল আৰসি পান কাৰ্ড আধাৰ কাৰ্ড ভোটাৰ আইডি দোকানৰ চাবি মটৰচাইকেল কাৰি মোৰ ভাইটিক মাকৈ খেতিত পেলাই দি পদকীয়াগণে পলাই যায় আৰু মোৰ ভাইটি চিঞৰ বাখৰ কৰাত স্থানীয় ৰাইজে ঘটনাস্থলীত আহি মোৰ ভাইটিক অধিক সংকটজনক অৱস্থাত দেখি তৎক্ষণাৎ বিলাসীপাৰা হস্পিটাললৈ পঠাই দিয়ে আৰু ভাইটিৰ অৱস্থা অধিক সংকটজনক দেখা পায় উন্নত চিকিৎসাৰ বাবে ধুবুৰী মেডিকেল কলেজলৈ প্ৰেৰণ কৰে আৰু তাতে ডাক্তৰে জখমী গুৰুত্ব দেখি তাৎক্ষণিক চিকিৎসা গুৱাহাটীৰ জিএমচিলৈ প্ৰেৰণ কৰে আৰু মোৰ ভাইটি বৰ্তমান মৃত্যুৰ লগত যুঁজি আছে This is the allegation, Lordship. Now, Lordship, the true story is that, Lordship, the petitioner number 1, Lordship, her marriage was fixed on 25/3/2026, Lordship. Technically, to stop the marriage of the petitioner, Lordship, they have filed this present FIR, Lordship. They have lodged this FIR on 24/3/2026, Lordship.
Lordship, my submission is that, Lordship, we are totally unknown about his something happened or not. We are totally unknown, Lordship. There is no any such markpit has taken place, such incident has taken place, Lordship. Now, Lordship, kindly, Lordship, they have filed an objection, Lordship. Objection, Lordship, kindly at page, Lordship, 33 in their objection, Lordship. Very surprisingly, Lordship, the incident has, according to them,
33 is an injury report.
33 in their objection, Lordship. 33
No,
page.
it's an injury report.
Injury report, Lordship. Very surprising thing is their, Lordship. Kindly, Lordship, on top, Lordship, report register number 109 2026, Lordship, and dated, Lordship, 7/5/2026. Kindly, Lordship.
7/5. May.
7/5/2026. This is registered on 7/5/2026. Bottom portion, Lordship, where signatory was done, Lordship. It was signed on 2/5/2026. So the injury report was registered on 7/5/2026. How it can be signed on 2/5/2026, Lordship? Injury report, Lordship. There, Lordship, another thing is there. Bilasipara case number 91/2026, dated 30/4/2026, Lordship. But in the affair 24/3/2026, in injury report, Lordship. And as per the allegation, Lordship, as per the allegation and their content, Lordship, they have first admitted to Bilasipara Hospital, then, Lordship, Dhubri Hospital, and then GMC. And the last version, Lordship, he was treating, he is fighting with his life in GMC as per their FR, Lordship. Here, a X-ray report is annexed, Lordship, by the respondent, Lordship, page 34. X-ray report, Lordship, bottom, Kokrajhar Medical College on 10/4/2026, Lordship. The incident was happened, Lordship, 23/3/2026. X-ray was done 10/4/2026, Lordship. And Kokrajhar Medical College, Lordship, there is no sound of Kokrajhar Medical College in the affair, Lordship. So absolutely concocted case, Lordship, fabricated case, just to stop the merits of the petitioner, Lordship. All members are implicated, Lordship. That, Lordship, CD is there, Lordship. Lordship.
Yes, Lordship, what I have understood from his submission is, Lordship, that no incident happened and the injury report is false. That is the prime submission. Here, Lordship, the incident, first, Lordship, he was found in a very critical condition. Thereafter, he was taken to Dhubri Medical College and hospital, and thereafter he was referred to Patna. And after Patna, I don't know, Lordship, Patna, Lordship, there is no report as such, Patna, but thereafter, Lordship, he was again referred to Kokrajhar Medical Center and hospital. And all these reports are in the CD. Only thing, Lordship, the Patna is not in the CD. Patna reports, if he was shown, they can shed light on that, Lordship. And Lordship, here the injury report, if Lordship kindly takes up, it's in the CD also. There, Lordship, there is grievous injury. In two parts, his fracture is there, Lordship. And one is simple injury. Now, these two grievous injuries are, Lordship, fracture head of left radius with displacement of fracture fragment, X-ray hand, and his whole elbow was dislocated, Lordship. So there is one witness, Lordship, that when he was beaten up, Lordship, he somehow managed to escape, and then this witness found him. He was holding his hand, Lordship, because his hand was hanging, Lordship. It was dislocated, Lordship. And then, Lordship, elbow joint, forearm, all these are fracture, Lordship. And Lordship will see the photograph is also there of his injury. And he was admitted in Pokrajan Medical Hospital on 3/4/26. And he was discharged on 11/4/26, as per the report of the Pokrajan Medical College Hospital. And Lordship, in this type of cases, Lordship will find that the injured victim's statement is of paramount importance, Lordship. He has taken specific names of all these petitioners, how he was assaulted. And there are witnesses, Lordship, who have not seen the attack, but they have seen when hue and cry was raised, one of the witnesses seen the accused person running away from the spot. So Lordship will kindly take up the case study. I have flag marked all the relevant portion. That is the case, Lordship.
Yes.
May I please, Worship? Besides what my learned friend has submitted, my lord, I'd like to take you to his petition, page 4, paragraph 3, my lord. All along, my learned friend is submitting, nothing has happened, my lord. Nothing has happened. And this is primarily, they have stated, a big picture trying to project that there is the marriage is the bone of contentions. And this is contrary to the materials on record, my lord. Nothing has happened. There is a good phrase, once nothing has happened, my lord, something serious has happened. And this is the case, my lord. They have denied nothing has happened on 23, my lord. Second ultimate line, my lord. At least my friend has candidly agreed that nothing has happened on 23. I am not saying what has happened on 22, my lord. On record, as per FIR, every incident happened on 23 night at 9:30, my lord. And he has said that it is his language. The petitioner are submitting that on 22/3/2026, there was no any incident was taken. Page 4, paragraph 3, my lord. His petition, my lord.
Yeah.
And then it continued in paragraph 4, the same line that nothing has happened, my lord. No such incident has happened. Naturally, my lord, the question comes, my lord, from where this medical report, injury report, physical evidences, digital footprints, and all medical report has come, my lord. And I'm on record, my lord. My learned friend was kind enough to apprise this court as far as medical injury goes, my lord. They have that in my petition, page number 34, my lord, to the extent that it was a premeditated. They have attacked me so brutally and restrained me and taken my, besides this 30,000 rupees, all my important documents, my lord. And my learned friend was categorically ignored one thing, my lord, as far as criminal incident of all this accused is concerned, my lord. The first accused father was a murder accused, my lord. And categorically, they have nowhere they have stated in their petition, my lord, about the criminal antecedent, which is a vital point, my lord. It is an incredible approach. Nowhere in the petition, my lord, clearly indicate that Umme's father was accused. And here, my lord, I'd like to submit, my lord, page 31, fractured head left radius. This is a permanent displacement, my lord. And fracture was to the extent, my lord, I was initially referred to the medical college. Medical authority asked me for better treatment. I came here in Gauhati. Then again, as per the advice of the doctor, my lord, I, as a poor man, my lord, I went to the Patna hospital and then I come back again and I'm undergoing the medical treatment, my lord. And my learned friend is stating that nothing has happened, my lord. Why I will bring all these records, my lord, and police will unnecessarily furnish medical reports, my lord. And my lord, they are habitual offenders, my lord. Besides this, Umme's father was involved in a murder case that is pending, my lord. They are so influential, my lord. considering the gravity of the offense, my lord, and their criminal antecedents, my lord, that can do anything, my lord. Releasing them at this stage, my lord, in this petition, my lord, will hamper our not only the investigation part, my lord, to our health as well, my lord. So considering the materials my learned friend has placed, my lord, as far as CD perusal, my lord, I'm resubmitting, my lord. They are in flight risks. Immediately after getting the bail, my lord, they will intimidate the witnesses and they will abscond, my lord, and they will temper the evidences, my lord. At this stage, my lord, yes, my lord, and my life it has risks, and this is what I have stated in our FIR, my lord. So my respectful prayer will be considering the medical report, my lord, considering their criminal antecedent, my lord. My respectful prayer will be not to allow to go on bail at this stage in this petition, my lord.
Lordship, my learned friend has submitted. I have mentioned that nothing has happened, Lordship. Only one portion he has read, Lordship. Kindly, Lordship. The petitioner are submitting that on so there was no any such incident was taken place, and Lordship, there is no any information to the accused person, Lordship, regarding such incident. That line, Lordship. There is no any information to the petitioner's, Lordship. Lordship, where they are claiming that they are not involved, they have no any information. How can they know something happened or not happened, Lordship? Kindly, Lordship, what I have submitted in the injury report, Lordship, the date, Lordship, discrepancy of date, that cannot be accepted. Very discrepancy of date, Lordship, injury report, kindly.
I mean, but you're saying that they have not took any treatment at Kokrajhar, but the report says that they admitted in Kokrajhar.
There is no sound about Kokrajhar in the affair. That is why I am submitting, Lordship. And they have said to GMC, Lordship, to GMC. Last version in the affair, Lordship. Kindly, Lordship.
Now, how can you deny that at the time of lodging the FIR, obviously he was treated in GMCH?
Yes.
Because his critical condition was. Therefrom, as per the report of submission made by the informant, as well as from the CD, it reveals that thereafter he was, as per advice of the medical team, he was, referred to Patna. And from Patna again, he was admitted in Kokrajhar.
Maybe.
So now you're saying that Kokrajhar, obviously there is no mention about Kokrajhar in the FIR, because at that incident time of relevant time, he was admitted in GMCH undoubtedly.
Lordship.
So now how can you say that there is a dispute?
Now, Lordship, one more thing, Lordship, I have filed an additional affidavit, Lordship. Kindly, Lordship. Yes, 20 on, Lordship.
20.
Yes, Lordship. Additional affidavit, Lordship. This is a
Government employee.
Google photo, Lordship, GPRS photo, Lordship. This is this photograph 21, Lordship. Photograph of injured person, victim, Lordship. 21 additional affidavit, Lordship. And Lordship, kindly, Lordship, page 18, additional affidavit, page 18, I have mentioned para 3, Lordship. Para 3.
No major injury.
Additional affidavit, last in the file, Lordship. There I have mentioned, Lordship,
Hmm.
para 3,
Hmm.
that the brother of the informant, Lordship, got an bike accident, Lordship, as per our information, Lordship,
Sure.
specifically mentioned, Lord.
He made it on bike accident.
Yes, Lordship. Bike accident, it was a rainy day, Lordship. That's why bike accident has taken place, Lordship. Lordship.
This is by this what I have understood, my lord. Total contradictions, my lord. In one front, what I am trying to, my learned friend is trying to project a big picture about nothing has happened. This is again the contradiction. He said, my lord, I just like to read. It is further discovered by the innocent petitioner that the injured person is very much fit now and continuously running his shops in medical shop. And due to rainy day, no major injury was taken place, my lord. In one front, he has denied that nothing has happened. In page 4, paragraph 3, 4, and 5, my lord. Again, no injury, my lord. So total contradiction, my lord. And the picture they're trying to project is basically the marriage is the bone of contention, my lord. Ultimately, marriage has taken place on 25th, my lord. This is, I'm on record, my lord, page 5, paragraph 3, my lord. The big pictures about the marriage, time and again, my learned friend is referring that marriage is the bone of contention, my lord. Ultimately, marriage took place, my lord. So this doesn't hold any water, my lord. And in a manner, they have gruesomely attacked and then put me in Cronfield, my lord, leaving none to attend. And thereafter, Passerby has taken me there in the hospital and immediately medical attention that I got, my lord. And now he is denying that nothing has happened, my lord. On this count alone, his petition is required to be dismissed, my lord. Because he has not come in clean hand, my lord. At least to some extent that something has happened, my lord, that was not serious. To the extent it was possible, my lord, he has totally denied that incident has happened, my lord. Now, coming to the picture, my lord, he is also questioning the state authority, my lord. Police CD is not in my hand, my lord. Police has brought all this record, my lord. This is my humble submission. At least in this petition, my lord, this prayer should not be entertained, my lord. This is not, and otherwise they will cause further injury to us and our family, my lord. This is my respectful submission before this court, my lord.
Lordship.
Okay, it will never ending process. That's
Lordship, kindly, Lord. I am not denying,
You
Lordship.
already
We have no any information about the injury, Lordship. Now, Lordship, I have annexed these photographs, Lordship. These are Google photographs taken on 7/5/2026, first on, and exact 21 page. And this person is running his shop, Lordship, on 12/5/2026. Now, Lordship, regarding his injury that is in the CD, Lordship, I have raised out the question, Lordship, regarding the injury report, Lordship. That was, Lordship, register on 7/5/2000. Yes, Lordship. That part, Lordship. How the report, Lordship, register on 7/5/2026. How can issued on 2/5/2026, Lordship? Before 5 days, Lordship. Before 5 days, it is already signed. Even not registered, but signed by the doctor, Lordship. That part may be considered, Lordship.
But so J is not. But Mr. J is not the learning of so far. Submission the learning petition everyone. And Mr. A is the learning council appealing for. Should I record your name also?
All right.
Okay, we'll record your name.
My lord.
Of that also hard Mr. TJ.
Sorry, my lord, vote number 1, I am addressed going on.
The TJ Mondo, the learned senior assisted by Mr. J. is automatic. Next prayer is submitted by whom then? By you? By Islam that they present these petitioners are innocent and they have not committed any such offense as alleged in the act. However, the marriage ceremony of the petitioner number 1 is fixed on 23 2026, and only with the intention to stop the marriage of the petitioner number 1, they have created a story, and then FIR has been lodged with some false and conclusive allegations. Nothing had happened as alleged in the FIR on the day of incident and the day of incident, and there is no information to the present petitioner if any incident had happened on the on FIR was lodged on which date?
24th, my lord, if I am not.
24/3. 24/3.
22/4/3/2026.
22.
24/03/26.
24/03.
Yes, ma'am. Medical was done on 24th immediately.
So you're saying prior to one day the incident happened, so your marriage was fixed on 25th?
25th.
25th or 23. Marriage was fixed on so, and one day marriage was fixed on 25/3. And only with a view to stop this so and so. Possibly listen in so and so. The FIR last line to keep. Happened on 24/3/2026 as allegedly. Mr. Islam further submitted that in the written objection filed by the informant, the one injury report and one X-ray report is also furnished along with the written objection. It is seen that the injury report was it is seen from the injury report. Seen from the injury report. That the injury report was what is your wording? It was registered.
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 Injury report, can it be injury report? Can injury report be registered?
Yes, in the injury report it is clearly.
No, it is registered. You are saying registered. Actually. Okay, injury report seems to be registered on 7/05/2026, wherein the doctor who issued the certificate injury report had put his signature on 2/5/2026, that is 5 days prior to the date of registration.
Moreover, Lordship, they have mentioned the case number, Lordship. Their registered date also wrong there. 34.
Apart from that, the date of
Dated 34.
it is GD number or case number? 91 is the GD number or case
GD number, case number also shown.
Case number is 91?
91 2026.
And he mentioned in the case number is 91 of the 2026, dated 34/2026 in the injury report, which itself contradicts the allegation made in the FIR, as per which the incident took place on 24/03/2026. He further submitted that one X-ray report is also furnished along with the objection, wherein it seems to be issued on 7/4/2026 from Koprachar Medical College and Hospital. So there is no mention about any treatment in the Koprachar Medical Hospital in the FIR. As per FIR, the treatment was provided to the victim in GMC. Accordingly, he submitted those contradictory statements and the contradictory documents submitted by the informant side itself proves that they're trying to brought a false and concocted story only for the previous grudge against the petition. Supposed to. Mr. Some, however, submitted that all the petitioners are ready and willing to extend their cooperation in further investigation of this case if they are granted with the privilege of readest bail. Next para. Mr. Sharma, the learned additional people submitted in this regard that there are sufficient implementing materials against all the three petitions and petition post. The party submitted that initially the victim was admitted in the Hubli hospital, where from he was shifted to GMC, and under reference of the doctor, the petitioner was, the victim was treated in the hospital of Patna, and then again, as per the report, he was again took his treatment at Koprajhar Medical College and Hospital. Accordingly, Mr. Sharma submitted that there cannot be any such discrimination in regards to the treatment taken by the victim in GMCH as well as Patna and Koprajhar Medical College. Next part, Mr. Sharma further said that they have found 2 previous injuries on his person, along with 1 simple injury. It is a fact that there is no such eyewitness to the incident, but one of the eyewitness saw the victim while holding his hand, wherein his ankle was found to be dislocated for the injury sustained by him. Apart from that, there are other eyewitnesses who saw the accused persons while fleeing away from the place of incident. Mr. Sharma further submitted that he was admitted subsequently he was again admitted in Koprajhar Medical College and Hospital on 3/4/2026, and he was discharged on 10/4/2026 from the Medical College and Hospital. Mr. Sharma accordingly submitted that the prayer for anticipatory bail of the present petitioners may not be considered at this stage. Next one. Mr. Tapada, the learned the period for the informant, raised a objection and submitted that the petitioners made contradictory statement in their petition as well as their petition. He submitted that in one hand, they are saying that nothing had happened on the day of incident. And on the other hand, in their additional affidavit, it is stated that there was the victim met with an accident on the day of incident, which itself seems to be contradictory. And that apart, there are some criminal antecedents for the petition, as the father of the accused petitioner number 1 is an accused of a murder case which is still pending. Mr. Tapada further submitted that all the accused petitioners are still threatening and they are very dangerous person. Accordingly, there are not only flight risks is there, but there are probability of tampering with the evidences of the investigation, tampering with the investigation. And the life of the victim is also at risk.
My lord, petitioner number 4 is a government employee, my lord. He is, my lord, there is actually, my lord, only by if your lordship go by injury report, I have nothing to say, my lord. But my lord, so far is, my lord, at the night, my lord, nobody has seen, there is no eyewitness, my lord. So, my lord, omnibus statement, they have an entire family, my lord. So, your lordship kindly consider say against whom, my lord, there is a specific allegation. If there is a correct, my lord, if there is any eyewitness is there, my lord. So, here, my lord, your lordship saying something, my lord, because not a single member they have left, my lord. Entire member of the family has, my lord, entrangled, my lord. They have, my lord, made allegation, my lord. So far is, my lord, Item number, that is CL number 4, my lord, is Ustam Ali. He is a government employee, my lord. There is no chance of any absconding, my lord. So it can get his case may be considered, my lord.
Further, it is submitted by Mr. Tabata that the bone of contention of the case is that only to prevent the marriage of the accused petitioner number 1, the affair has been launched with some false allegation. But the as per the information received from the informant side, the accused petitioner number 1 already got married on 25/3/2024, the date which was fixed for her. So further accordingly raised the objection and submitted that
I have annexed the I-card, his page 20 is the I-card, my lord.
not at all the case to extend the privilege of pre-arrest bail. Present. Next part. Mr. Mohanto, the learned senior counsel, submitted this regard that all the family members of the petitioners have been entangled in the case, and there is no eyewitness as to who, there is no evidence as to who, specific as to who the assaulted the victim, or who is assaulted the victim for which he sustained such an injury. Also, the accused petitioner number 4 is an government employee, and the guard is also punished, and thus there cannot be any prejudice the accused petitioner number 4, who is one. Mr. Sharma, Mr. Mohanta has raised the issue that whether there is any specific mention. Your submission, we have already recorded that one eyewitness was there who saw that he is holding his hand and gone.
Yes.
And one eyewitness is also there who saw that drifting away from the place of incident. Apart from that, is there any specification as to who?
Yes.
Yes.
Let's will just hand over meeting for a moment. Double zero.
Yes. No, ini mati kok kue itu. Kue dua kali ini. Mana ini?
Everyone would.
Just we are taking this matter based on it. Mr. Day, you are going to argue this one? Item number 11.
Lordship, in this matter, final report has been submitted. We have challenged the FIR. We are praying for question of the FIR. So basically, it has become infructuous, Lordship.
M. Sharma was there for the response number 2. Okay, then we are taking up your matter. Just a second. Yes, Sharma, what is it?
Lordship, everyone has been mentioned.
Everyone. Name.
Everyone. I have double verified that.
In that context, Mr. Sharma, the learned additional people, has submitted that the name of every petitioner has been specifically mentioned in the specifically mentioned by the victims as well as the eyewitnesses who are the name of everyone. This is again victims in the statement recorded. Next. During the submission made by the counsel for persons, I have also produced a case record, the the affidavit in opposition, objection, and other relevant annexures filed along with it. Pardon, the case diary was also produced. One of the issue raised by the learned counsel for the petitioner that there's a discrepancies in the medical documents which are submitted by the informant while submitted by the informant along with their objection petition. But on the result of the record, it's seen that the one, Mr. Sharma, they have, Mr. Tapada, they have also submitted one report from which hospital, I don't know.
Yes,
Along with your objection petition, it is from which hospital?
Page 31, fracture path.
No, it is page 33. No, CD is there available? Is it available?
33, this one looks it.
Yeah.
Yeah, it is available.
It is there in CD man. Original there in the CD man.
Original there in the CD.
Yes, it is there. Lordship, if Lordship requires me to clarify this aspect, I can clarify Lordship. Because they have pointed out the discrepancy, I can clarify Lordship. Shall I clarify Lordship?
You can clarify. I also myself clarified, but you can clarify. Yes.
Lordship, what is Lordship will see, he was.
I also clarify.
Yes, he was examined on the same date, Lordship. Then Lordship, the reports are taken, the examination is done. Thereafter, after perusal of all these things, Lordship, this report is made. Signed on that day. Thereafter, this report goes to various departments, Lordship. And thereafter it is
issued only.
Yes.
That is, I know.
Yes.
That's why I have said nothing.
Yes, Lordship.
I know this is only date of issuance.
Yes.
Yes. Oh, date of discrepancies kilo dito na? Seen that record as well as from the medical report. Oh, sorry, my case diary. It is seen that that injury report was issued by the Dubri Medical College and Hospital on the day itself when he was provided with the treatment, and the date of and the doctors issued the report on, and a doctor signed the injury report on 2/5/2026, but it was subsequently issued on 7/5/2026 after the registration of the injury. Thus, there cannot be any discrepancies in the injury report as raised by the learned counsel for the petition. Apart from that, there is also medical documents from Kokrajhar Medical College and Hospital, where from it is seen that the victim was admitted in the Kokrajhar Medical Hospital after he was released from Patna, wherein he was admitted and undergone treatment for a sufficient period. That from the FIR, from the report, from the case diary, it also seen that if the victim sustained two previous injuries on his person, including one simple injury, and the eyewitnesses also saw the accused petitioner fleeing away from the place of incident at the relevant time. Post. From the statement made by the witnesses as well as the victims, also seen that all the accused petitioners seems to be involved in the alleged offense when the victim was brutally assaulted by them. So, considering the materials in the case record submission made by the land counsel and also considering the submission made by Mr. Tapada regarding the risk of the informant, this court is of opinion that anticipatory bail for the accused petitioner may not be granted at this stage. However, the accused petitioner number 4, who is stated to be a government employee, is seen that there may not be any such right risk who is right risk, and considering only this aspect of the case, the prayer for petitioner number 4, petition number 4, who is petitioner number 4 is Rustom Ali Mujumdar, is hereby granted with privilege of pre-arrest bail with the following terms and conditions. Petition number 4 is granted with the previous pre-arrest bail. Therefore, the pre-arrest bail for the other accused petitioners, but namely Buckingham Hill so and so, is hereby rejected. 4 is considered, others are rejected.
Deeply applied. Deeply applied.
So you're saying that FR has been.
Yes, Lord. So our
Yes,
prayers are.
you are also here, I think state is there or no? State is here. From where you are saying, FR?
Lordship, we had
Report is
filed.
received?
Yes, yes. We had approached the learned magistrate for custody of defreezing our account. The report had come to the learned magistrate, and we learned that the final report had been submitted in that case. We have also procured a certified copy of the final report.
This is with you now.
I have a soft copy, Lordship. If it is.
Do you have any information, Mr. Chair?
Lordship, I do not have the information.
So at present too, we don't have. On the basis of your submission, it can be closed.
Lordship.
If FR is already there, question of further continuation doesn't arise. But you just tell us the number, FR number.
FR number 197/24 dated 31/10/2024.
197.
Lordship.
197/2000.
24.
24.
Lord.
Dated
31/10/2024.
31/10/2024.
Lord.
Heard Mr. P.S. Day, the learned counsel for the petition, and also heard Mr. B. Sharma, the learned counsel and PP, agreeing on behalf of state president. Otherwise, you have received the case diary or what you have received?
We have not received a scam. Probably records was called for.
Record was called.
Record was called for me. Record নহয় মানে CD টো কল কৰিছিল
কি হৈছে?
এফআই প্ৰশ্নৰ কাৰণে কৰিছিলে ন তাৰ পিছতে দিছিল
That record not received. No, hard click na. Case was for efficient hearing. However, it is submitted by Mr. Day that as per the information of the instruction, the case has already been cases ended with effort, and regarding the acceptance, do you have any information?
No, Lord.
FR by FR number 197/2024 dated 31/10, and accordingly, in view of the submission of the final report, the petitioner is not does not want to raise the petition further. Considering this submission made by Mr. A, the present criminal petition is hereby closed as rendered. Okay.
Much obliged.
16.
For the petition.
Lordship, most of the time they're taking absent, Lordship. There is an order for paying area maintenance, Lordship. Now it is around 4,15,000 is balance, Lordship.
On the last occasion also they remain.
Yeah, Lordship. Your Lordship asks us to pay at least some certain amount.
Yes.
They paid only 25,000.
On 23/03/2026, they were there.
Lordship.
KK Handy was present. So there was some direction, and then on the last occasion, that is on 28/4, they again remain absent.
Lordship.
taking too much indulgence.
So now they, till then they are not paying any.
4,15,000 is arrear lordship. And monthly 15,000. Monthly they are paying, but arrear they are not paying. Let them clear it out with certain installment in.
No, while they are suppose paying the monthly maintenance, the issue of this area maintenance is not there, or you have not raised that issue.
That issue there.
For area maintenance.
No, there is a stay order for to pay 1 lakh. Thereafter, there is a stay order while it was admitting.
Stay order is there. Stay is operating.
They prefer,
Why he is
they prefer
absent?
revision before this court that was rejected. The direction of the maintenance that has been rejected. Your lordship has passed this judgment. Lordship. Let them fix their lordship in next week any day, lordship.
Can you personally inform him so that next day at least or some order can be passed, or else we'll packet the stay order and will be disposed of
Lordship.
otherwise. If they are not present.
Lordship.
No representation has been made on behalf of petition on call. Had Mr. E. Chakraborty, the learned counsel deputy to the respondent. Mr. D.P. Goswami, the learned additional PP approved for the state respondent. It reveals from the record that on the last occasion also the petitioner remained absent. Further, it is submitted by Mr. Chakraborty that they are not paying any money towards the area maintenance, which at present accrued more than 4,15,000. In view of this, let the matter be listed on it. June 10th of June. 10th of June, and consequential order may be passed in absence of if the petitioner remain absent. Okay. Yes, you have received this scan copy here. No?
Copies have been received, my lord. Otherwise, both parties are here. So lordship is inclined to take it up because it takes some time also, my lord, for disposal, my lord.
If you finish it up by, say, by 4:15, it will be okay.
So by
Because we
4,
have
my
a
lord,
meeting.
my lord, by 4 it will be
By
okay.
4.
By 4.
By 4 then okay.
So this is a
Because
case.
we have a meeting.
Well, this is a case where a complaint case has been filed by the respondent number 2 against the petitioners, my lord.
You are for the petition.
I'm for the petitioners, my lord. 7 petitioners, my lord. So in that case, my lord, cognizance of offences were taken under sections 447, my lord, criminal trespass, 294, 323, 506, and 34 IPC. And this honorable court was pleased to stay the proceedings primarily on the ground that, my lord, the civil dispute, a land dispute, has been going on between the parties. And this civil dispute has been given this criminal color, my lord. If your lordship will kindly come to my petition, my lord, page 4, my lord, given the brief narration of the facts, my lord, that led to the filing of the complaint case, my lord.
Page 4?
Page 4, my lord, of my petition, my lord. From para 2 onwards, my lord. I'll just read these 4 paragraphs, my lord, just to get the facts, my lord. The petitioners, from para 2, my lord, the petitioners are the cousins of the respondent number 2, and both parties are embroiled in a civil dispute over inheritance of a plot of land, my lord, measuring 4 bighas covered by dark number so-and-so and patta number so-and-so. This land, my lord, the land in question originally belonged to one Kartik Satnami, who sold the land to one Mukaddas Ali, who in turn sold the land to the paternal aunt of the petitioners, Khairun Nessa. Well, this Khairun Nessa plays a pivotal role, my lord, here. This Khairun Nessa is the paternal aunt of the petitioners, and this land was sold to her. So Khairun Nessa was issueless, and her husband, Siddiq Ali, he also predeceased her. Siddiq Ali had another wife, Fatima Khatun. That Fatima Khatun is the mother of the respondent number 2. After Khairun Nessa died in 2006, his property in question devolved upon her siblings, Intaz Ali. Intaz Ali is the father of the petitioners. Alkas Ali, Hayatun Nessa, and Joinab Bibi. Later on, that Alkas Ali, Hayatun Nessa, and Joinab Bibi gave up the rights of the property in favor of Intaz Ali. Thereafter, Intaz Ali died in 2007, and the property in question devolved upon his children, that is the petitioners, my lord, and their siblings. Petitioners continued to possess and cultivate the land in question till 2016. In January 2016, the respondent number 2 and his sister, Joygun Nessa, requested the petitioners 2, 3, 4, and 7 to allow them to cultivate the land on condition that they would give half of the produce to them in the month of January of each year. On such conditions, the petitioners number 2, 3, 4, and 7 allowed their request. Respondent number 2 and his sister gave half the produce up to the year 2020, thereafter stopped doing so. Eventually, when the petitioners requested them to vacate the land, the respondent number 2 and his sister refused to do so. The petitioners and the respondent number 2 held multiple meetings in order to resolve their land dispute, but to no avail. So this is the background of the case, my lord. This land was there. Khairun Nessa got the land. From Khairun Nessa, this land eventually devolved to the petitioners. Respondent number 2 came and took possession of the land to cultivate the land. Supposed to give half of the produce. After a point of time, they stopped. So then thereafter, my lord, these petitioners, they filed a title suit. Now, your lordship will find the titles with the plaint of the title suit, my lord, at page 15. This title suit, if your lordship will kindly come to page 17, is a suit for declaration of right, title, and interest of the plaintiff over the suit land, and for recovery of possession and permanent inheritance. This possession was already in the
These plaintiffs are the
petitioners and their siblings. Petitioners and their siblings. They filed this suit, my lord, that suit is still pending. Now, when the petitioners filed this suit, petitioners found out that this respondent number 2 had filed a complaint. This complaint, which we are seeking quashing of, respondent number 2 had filed a complaint. Now, the complaint, your lordship, was filed on 27/2/2023, and we filed the suit on 22/11/2023. So technically, they filed the complaint first. We filed the suit later.
You filed the suit on 22/11.
We filed the suit, my lord, on 22nd of November 2023, 22/11/23. They filed the complaint on, my lord, 27/10/2023. So almost a month prior to us, they filed a complaint. But that was a time, my lord, when CRPC was there, so there was no precognizance notice. We were not aware of the pendency of the complaint case. Initial deposition was taken in January, and eventually in February, summons were issued, my lord. So after issuance of summons, then we found out that the complainant had filed a case, my lord. So one of our contentions before this honorable court is that this is a land dispute which is existing there between the parties. And in fact, my lord, I will show from the record also, they have also admitted. In fact, they tried to get them, because the land was mutated in our name, they even tried to get the mutation cancelled. So because of this existing land dispute, my lord, this civil property dispute has been given a criminal color. Now, another thing, your lordship will kindly come to the complaint, my lord. No complaint. Page 33, my lord.
This is a complaint.
Is the complaint, my lord. The impugn complaint. And page 34, the complaint starts, my lord. Small complaint, my lord. May I read, my lord? Sir, the complainant most respectfully begs to state that after the death of the complainant's grandfather, Amir Ali, his legal heirs mutated his property covered by DAG number so-and-so, situated in so-and-so place. But the aforementioned accused number 1 got the land mutated in her name, projecting herself as a heir of late Amir Ali. Accused number 1's actual father is Intaz Ali. After accused number 1 got the land mutated in her name, the accused persons occupied and misappropriated 1 bigha 2 katha and 5 lesa of land covered by DAG number so-and-so, situated so-and-so place, which was inherited by the mother of the complainant, namely Khairun Nessa, from her father Amir Ali. A meeting was called for in this regard after the complainant informed the village elders about the issue. Though in the meeting, Khairun Nessa, since deceased, had asked the accused persons to return 1 bigha 2 katha and 5 lesa of land to the complainant, but the accused persons did not pay any heed to the direction. As a result, the complainant submitted an application in the Doboka Circle office seeking cancellation of the fraudulent mutation. So the fact that the mutation was there and the fact that they tried to get it cancelled is there apparent from their complaint. However, surprisingly, this is the bone of contention. However, surprisingly, on 24/10/2023, at about 10 a.m., the accused persons went to the house of the complainant, and when the complainant came out to the veranda of the house, the accused persons abused him. The accused persons surrounded the complainant, and accused numbers 1 and 2 shoved the complainant to the ground. Consequently, the complainant sustained injuries on his arms and legs. On hearing the hue and cry raised by the complainant, the neighbors arrived at the place of occurrence. The family members and the neighbors rescued the complainant from the accused person. The accused persons also threatened the complainant that if he tried to cancel the mutation of the land in the name of the accused number 1, they would drag him from the road, break his arms and legs, and throw him in the Kopili River. So substance remains the land dispute. Now, these elements have been brought in by them to convert this, because the property dispute title suit will take care of that. These allegations have been brought in primarily to give it a criminal color. So, my lord, in a complaint case, my lord, when the court decides to issue process under 204, the court does not issue process on the complainant. Your lordship kindly have 203, and your lordship knows only 203 and 204. Upon considering the initial deposition of the complainant and the statements of the witnesses under inquiry. So your lordship will kindly see their statements, my lord. Page 39 is the statement of the complainant, respondent number 2. Page 39, madam. May I read this, ma'am? I filed this case against Moimun Nessa Asabali so and so so and so. 204 nong Miadi Patta land bearing dag number 304 at Biloguri, Pathar Kisamater was in the name of my mother, Khairun Nessa. Accused Moimun Nessa by deceitful means registered the land in her name. On knowing the same, I informed the same to the Mondal, who assured me to settle the matter. On 24/10/2023, at about 10 a.m., all the accused persons came to my house and started to abuse me verbally. Moimun Nessa pushed me and I fell on the ground. Someone kicked me from the backside. After the incident, I went to the PS. The OC of Doboka PS suggested me to file a complaint case before the court. And my lord, the statement of the inquiry witness, my lord, will find it at page 43. Just 4 lines, my lord. I know the complainant, he is my neighbor, I know the accused persons. On 24/10/2023 at about 10 a.m., the accused persons abused the complainant verbally. Maimun Nessa hold and pushed the complainant. Asab Ali kicked the complainant. All the accused persons threatened the complainant. Now, the offences under which the court has decided to proceed against the petitioners, your lordship will see at page 48, my lord. 447, my lord. Criminal trespass. 294. Obscene use of obscene language. 323. Voluntarily causing hurt, and 506. Criminal intimidation. Now, if your lordship will kindly see the statement of the complainant, because irrespective of the fact that a land dispute is there, these offences are also not made out, my lord. 447 would involve criminal trespass. Now, for criminal trespass, my lord, that land itself is disputed. We have filed a suit. Suit is still mutated in our name. That part is also admitted by them. Suit remains mutated in my name. The subject matter of the suit as to whether I should get the land or they should get the land, that is still sub judice pending before a civil court. So even if we assume that we had entered into that land, my lord, that will not amount to criminal trespass when the land itself is still in my name, my lord. So that will not amount to 447, my lord. Next is, my lord, 294. Now, in her statement, even the inquiry witness, the 294 is predicated on the use of obscene words, man. Now, they have not alluded to any obscene words, my lord. They have not mentioned what obscene words. They have said I have verbally abused. Verbal abuse in itself is too wide a term, my lord, to bring it within the ambit of 294, unless they specifically specify what sort of obscene languages has been used by me. Secondly, 447 and 294, my lord, these two are antithetical. They will never go together, my lord. Because if they say it's trespass, then I have trespass into their private property, whereas 294 involves utterance of obscene words in a public place. So 294 and 447 will never go together, my lord. So these two are inherently contradictory, my lord. Third section is, my lord, 323, which is voluntarily causing hurt. Only thing which the complainant says is that Moimun Nessa pushed me and I fell on the ground. She has not mentioned that she has sustained any hurt. Medical, that's a different thing, matter of trial, but at least there must be some statement there that I have sustained hurt.
Implied if you push anyone on the
No,
ground.
no, but then, my lord, someone may fall and may not get hurt also, my lord. No, that is because they have come up with a prosecution. They want to prosecute me. So at least this much of effort should be there in their part to say that I have sustained hurt. They have not come up with, if it had been a case in which the court had proceeded under 352 criminal force, this would have been sufficient, my lord. They have specifically alluded to 323. Court has also gone ahead and taken cognizance under 323. For 323, primary requirement is that we must have sustained hurt. That is not there. And regarding 506, there is nothing regarding any threat. The complainant has not stated anything. The inquiry witness has stated, but complainant, who is the victim, does not mention anything about any intimidation matter. And more importantly, all the seven witnesses, seven petitioners, accused persons, they have been roped in by invoking 34, common intention. The fact that, my lord, there was any premeditation on their part, any prior meeting of mind, that has to come out, my lord, that is again not there. So my respectful submission before this honorable court is on two aspects. First, admittedly, a land dispute is there. So, my lord, in terms of clause 7 of Bhajan Lal, this is a clear case which has been vexatiously filed, attended with their malafides, because they are basically trying to convert what is essentially a civil dispute for which remedy is there. They are pursuing the remedy. We are also pursuing the remedy. Civil court will decide whatever has to happen. But they have now gone and given it a criminal color. Secondly, my lord, the other aspect is that the offenses under which we are being prosecuted, those offenses have to be made out. Even if it is a prima facie level, my lord, those offenses have to be made out from the statement of the complainant. That is conspicuously missing, my lord. So, my lord, I'll just rely on these three judgments, my lord, on this aspect. First, my lord, is Bhajan Lal, my lord, Lordship knows, my lord, para 105, my lord.
Okay.
Para 105. In the backdrop of the interpretation of the various relevant provisions of the code under chapter 14 and of the principles of law enunciated by this court in a series of decisions relating to the exercise of the extraordinary power under Article 226 or the inherent powers under Section 482 of the code, which we have extracted and reproduced above, we give the following categories of cases by way of illustration wherein such power could be exercised either to prevent abuse of the process of any court or otherwise to secure the ends of justice. Though it may not be possible to lay down any precise, clearly defined and sufficiently channelized and inflexible guidelines or rigid formulae, and to give an exhaustive list of myriad kinds of cases wherein such power should be exercised. My lord, first, we're relying here in this case, my lord, clause 7, my lord, the last one, my lord. Where a criminal proceeding is manifestly attended with malafide, or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused, and with a view to spite him due to private and personal grudge. So in this case, the existence of a civil dispute, a land dispute which goes back several years, my lord, and for which a remedy is there, clearly this criminal case has been filed vexatiously to give it a criminal color. Now, one issue may come up, my lord, because at the end of the day, complaint, they have made allegations. In the statement, they have allegations. So whether this aspect, the aspects which go beyond the complaint, can be examined by this honorable court, or this honorable court will only examine the materials which are there in the complaint. So, my lord, on that aspect, my lord, I rely on this judgment, my lord, Anupul Singh versus State of UP, my lord. Sorry, my lord, the other one, Sujoy Ghosh, my lord. Sujoy Ghosh, my lord, 2026, my lord. Here, your lordship will kindly come to para 13, my lord. Third page, my lord, para 13. The principles governing summoning of an accused in a criminal case, as well as parameters for quashing criminal proceedings, are well settled. Summoning of an accused in a criminal case is a serious matter, and criminal law cannot be set into motion as a matter of course. It is not that the complainant has to bring only 2 witnesses to support his allegations in the complaint to have the criminal law set into motion. The order of the magistrate summoning the accused must reflect application of mind to the facts of the case and the law applicable thereto.
The magistrate must carefully scrutinize the evidence brought on record and determine whether any offences prima facie made out. The magistrate may even himself put questions to the complainant and his witnesses to elicit answers to find out the truthfulness of the allegations or otherwise, and then examine if any offence is prima facie committed by all or any of the accused. Next paragraph. When an accused seeks quashing of either the FIR or criminal proceeding on the ground that such proceedings are manifestly frivolous, vexatious, or malicious, the court is duty bound to examine the matter with greater care. It will not be just enough for the court to look into the averments made in the FIR complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the alleged offence are disclosed or not. In frivolous or vexatious proceedings, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the averments, and if need be, with due care and circumspection, and try to read in between the lines. The court, while exercising its jurisdiction under Section 482 of the Code or Article 226 of the Constitution, need not restrict itself only to the stage of a case, but is empowered to take into account the overall circumstances leading to the initiation, registration of the case, as well as the materials collected in the course of the investigation. So here in this case, when we are specifically claiming that this case is frivolous and vexatious as well as malicious manner. So as per this judgment, this honorable court can also examine the circumstances and other factors beyond the complaint and beyond materials of record. The attending circumstances may be looked into, and the honorable court can also read between the lines to see if it was indeed a vexatious case or not. So that is one aspect, my lord, to take care of the fact that in the complaint or while recording the 200 statement or conducting the inquiry, the magistrate saw very clearly that there is a land dispute there in the complaint there. Magistrate should have exercised a bit more caution, should have been more circumspect before summoning the accused person, perhaps done more inquiry, ascertain what is the status of the case, who are the persons in possession, because 447 primary issue is that aspect, who is the owner of the land. Your lordship has seen the inquiry is very vague, only 4 lines of statements are there. So the magistrate was not, at least that part of caution was, abundant caution was not there. So summons were mechanically issued. These aspects were left out, my lord. That should have been done. The last judgment is, my lord, regarding this when if property dispute or civil disputes are there, whether criminal color can be given, my lord. That is, my lord, Anupul Singh, my lord. This is also a case, my lord, where there was a dispute over a plot of land, my lord, regarding 8.592 hectares. I'll just come to the relevant part, my lord. The lordship will kindly come to paragraph 11, my lord. 6th page, my lord. Before adverting to the facts of the present case, it is necessary to recapitulate the settled legal principles governing the exercise of inherent powers under Section 482 CRPC. It is well established that though the High Court possesses wide and plenary inherent jurisdiction, such power is not unbridled or unlimited, but circumscribed by self-imposed restraints evolved through judicial pronouncements. 11.1 is, my lord, basically Bhajan Lal, my lord, they have repeated. So 11.2, my lord. This court has consistently cautioned that the High Court, while exercising jurisdiction under Section 482 CRPC, cannot embark upon a mini trial or weigh the sufficiency of evidence which falls within the domain of the trial court. The scope of inquiry is confined to whether on a plain reading of the FIR complaint and the accompanying material, the ingredients of the alleged offence are disclosed. In Muhammad Alauddin Khan versus State of Bihar, it was reiterated that appreciation of contradictions or inconsistencies in witness statements lies within the exclusive domain of the trial court and not in proceedings under 482. Similarly, in CBS so-and-so, it was emphasized that High Court has exceeded its jurisdiction by examining the merits of the prosecution case and holding that the charges were not proved, which is a matter strictly for trial. So this part is settled, my lord. These things cannot be done. Now, next part, my lord. Nevertheless, an exception has been recognized where the defense relies upon unimpeachable, incontrovertible evidence of sterling quality, such as documents of undisputed authenticity, which ex facie demonstrates that continuation of criminal proceedings would be unjust and oppressive. This principle was recognized in so-and-so and followed in subsequent decisions. Thus, the cumulative principles that emerge are, while the jurisdiction under Section 482 CRPC is extraordinary and must be exercised sparingly, it is a duty of the High Court to intervene where continuation of criminal proceedings would amount to an abuse of the process of law, where the dispute is purely of a civil nature and criminal color has been artificially given to it. Conversely, where disputed questions of fact arise regarding adjudication, the matter must ordinarily proceed. Well, here we are going on the uncontroverted documents regarding the factum of the civil suit being pending, the factum of the land dispute being there, the fact that they themselves tried to get our mutation cancelled. So these aspects are there. So your lordship, you can see this was essentially a civil dispute which was given a criminal color, my lord. So in such cases, this honorable court can exercise its inherent power under 482 to secure the ends of justice, my lord, because basically a civil case, because they also know, my lord, the fact we also know, my lord, civil cases take years, my lord. It will go on for years. So this jurisprudence had to be developed because people had eventually started coming to the criminal courts with criminal cases, knowing that somehow this will create some pressure upon the plaintiff or the defendant, or this will lead to some sort of a compromise, my lord. That has been one of the reasons why in almost every civil case, one invariably sees that there is a criminal case, my lord. So this is regarding the vexatious part. Regarding the other part, my lord, their own statements, my lord, on oath before the magistrate does not disclose prima facie materials of any of the offences. 447, 294, 323, 506, and they have not produced anything to club all of this by invoking 34. So this is a case, my lord, fit case where this honorable court can, my lord, quash the proceeding, subject to what my learned friend says.
Wait, please, your lordship. Wait, please, your lordship. Your lordship, if you had like to pinpoint the exact and contention of this entire quashing petition, it is with regards to the CR case number 819/2023. Here, your lordship, one thing which has been repeatedly mentioned with regards to the idea that the civil dispute has been given a criminal color. In turn, the facts of the case are clear that it's a criminal dispute which has been given a civil color. Why I say that, your lordship may kindly note that the date on which this particular criminal petition, which is under challenge, was filed on 27th of October 2023. At that time, there is no civil dispute pending. Lordship, there might be an executive petition for cancellation of the mutation which does not amount to a title suit or which does not amount to a civil dispute pending before any court of law. At that point of time, on 27th of October 2023, when this criminal activity happened with an intent which clearly signifies by the suit which followed, which means there was an enough intent with regards to all the accused persons when they trespassed into the house of this particular respondent number 2, and they choked him, heckled him, and pushed him to the ground, which was reaffirmed by the complainant and also the witness which was deposed before the magistrate, lordship. Now here, the chain of events categorically indicate that indeed there has been a criminal act which has happened. Now, whether that criminal act will subside just because there is a civil dispute pending, that is our first contention, your lordship. Furthermore, your lordship, the pendency of a civil dispute alone cannot be a license for someone to use physical force, criminal force, or outrageously enter into my property, into my house, heckle me, throttle me, and try to push me on the ground and also kick me and use criminal force against me. That particular civil dispute can never be an excuse, neither a license, your lordship. Furthermore, your lordship, may I kindly draw the attention of this honorable court to page number 39 and 40, which means when a complaint case has been filed, at the very first initial examination of the complainant, it is no strict proof that all the evidence has to come on record. It is just to bring the complaint into motion before the magistrate. Here, the complainant, who is CW1, he has deposed in page number 40 that on 24th of October 2023, 3 days prior to the initiation of this criminal proceedings, at about 10 a.m., all the accused persons came to my house and started to abuse me verbally. He maintained his honesty by saying that they started with verbal abuse, your lordship. Thereafter, Moimun Nessa pushed me and I fell on the ground. Someone kicked me from the backside. This is up to his honest remarks with regards to the magistrate on oath. Furthermore, in page number 43, your lordship, where it is said that there is only 4 lines of CW2, who is the witness of this particular complaint petition. Here he says that Moimun Nessa hold and pushed the complainant. Asab Ali kicked the complainant. In the initial deposition, he has said that someone has kicked me from the back. I don't know who has kicked me from the back, maintaining his honesty on oath. And thereafter, his witness who was there, CW2, he has reported, yes, Asab Ali kicked the complainant from the backside. And coming down to the sections which have been implicated, your lordship, 447 criminal trespass out of these 2 witnesses in a prima facie case is established with regards to the idea that they have entered my house illegally and with force. The reason being, they wanted to acquire my property. When they failed in this criminal activity, only then they went for the title suit.
It is not that the title suit followed this criminal case, which happens in most of the matter, that there is a title suit pending and then parties go for a CR case. Here, there was a CR case followed by a title suit which came next, just to ensure that now they are on the right platform and they are not coming to heckle me or threaten me into taking my property, Your Lordship. Now, if this case gets quashed at this stage, this will nothing but help the petitioners to fulfill the intent with which they started the criminal activity to take upon my property or that entire plot of land by force, Your Lordship. Here, criminal force will be nullified with regards to a civil dispute. We have no objection in our written submission. So we have said that the civil dispute may continue, that the title suit may continue. We are participating and we have submitted our written statement also. Nevertheless, why shall the criminal petition, which we have filed because we have received some criminal force with intent which is clear and the amount of harm which has happened to us, why should it be quashed only on the ground that there is a civil dispute pending? This is our entire case at large. They are not also negating the fact that this did not happen. They never said that that incident never took place. The incident very much took place. Both the CW1 and CW2 has deposed, and the deposition is clearly indicating the circumstantial evidences. And now the case goes for trial, Your Lordship. After the accused persons have come up and brought their defense story, where I will be cross-examined also. This is our humble submission at this stage, that the matter may not be quashed and the trial may be allowed to continue. I am ready for cross-examination and this entire proceedings may continue till, even if I have received certain blows which amounts to hurt, may the due punishment be granted to the person who is found guilty at the end of the trial, and not based on the statement alone, which is just for initiating and not a strict proof of examining the entire petition. That would be a humble prayer at this point.
Just 1 minute, my lord. Nothing beyond that. One thing, last thing, which is my learned friend said that we have not denied it. We have expressly denied it in our petition. Though in a criminal case, a burden is cast on them, we can still stay silent. But anyway, we have denied it. Para 14, page 9. That aspect. He has said that we have not claimed that this incident did not take place. So we have denied that part. Now, one thing which perhaps, my lord, some negativity may be cast because that is the somehow that is their point, is that this complaint was filed on 2710 and our suit followed it. But my lord, I have already pointed out, complaint may have been filed on 2710-2023. The statement of the complainant was recorded on 11/1/24. Cognizance and processes that was done on 22/2024. That is much beyond the initiation of the complaint case. So, my lord, the fact that a complaint case has been lodged by them, unless and until a summons is issued to me, there is no way for me to know that a complaint case is pending. So, this fact that it has been
your cognizance was taken on?
Cognizance was taken on 22/2024. Process was issued. And we filed it in 22/11/2023. So much before cognizance, the title suit had already been filed. The only thing which precedes the title suit is the fact that they had filed the complaint. But initial deposition, inquiry, cognizance, summons, everything followed after the suit was filed and notices were issued to them. Now, and last point is, my lord, what my learned friend has tried to submit is that by distinguishing the civil dispute with the title suit, the title suit may very well have been filed later on. The existence of the civil dispute goes back, my lord. And that fact is very apparent from their own complaint. Though my learned friend has said that it was basically an execution petition. But what was the purpose of that petition? The purpose of that petition was to get the mutation of the land, which was in the name of the petitioner number 1, to get cancelled. So this very submission that which we are making, that a civil dispute has been given a criminal color, that pertains to this existence of the civil dispute, not the existence of a title suit. These two things are very distinct. The civil suit was pending. In fact, they themselves admitted that they tried to get the mutation of the land cancellment. And that finds place in the complaint itself. So that precedes the complaint, my lord, the existence of the civil dispute. Suit may come after, suit may come prior to that. That essentially becomes secondary. Primary factor remains that the suit was the dispute was existing, my lord. And regarding the other aspects, just for your lordship, my lord, I'm just reading out 203 and 204, my lord. Is this thing, because one learned friend says that strict proof is not required. Of course, strict proof is not required. But for the court to proceed, application of mine has to be there on the materials. And what 203 says, if after considering the statements on oath, if any of the complainant and of the witnesses and the result of the inquiry or investigation under 202, the magistrate is of the opinion that there is no sufficient ground for proceeding, he shall dismiss the complaint and he shall record his reasons for doing so. And then 204 comes, if in the opinion of the magistrate taking cognizance of an offense, there is sufficient grounds for proceeding and the case appears to be, so then processes are issued. So the criteria is the statement of the complainant and the statement of and the result of the inquiry. Here, your lordship has seen the magistrate has miserably failed, my lord, in conducting a proper inquiry, especially when this factum of the civil dispute has been already admitted by the complainant. That part has not been there. Now, at least what the complainant could have done is brought in materials to support the allegations. 447 would clearly not come because this land is still in my name. They have not managed to get the mutation revoked, my lord. Land is still in my name. If I enter my land, my lord, I cannot be prosecuted for trespassing into my own land, my lord. If tomorrow the suit fails or they somehow succeed in getting the mutation cancelled or getting the land in their name, then maybe. As of now, I am the owner of the land, my lord. So when I enter my land, it cannot be trespassed. 294 cannot come with 447, and they have not stated what is the verbal obscene abuse. They say verbal abuse, not enough. Complainant has not mentioned criminal intimidation. She says that was shoved and pushed, fell on the ground, not mentioned that she has sustained. So if these primary things are not there, my lord, the ingredients are not there even on a prima facie basic level, my lord, then I cannot be prosecuted, my lord. That is my humble submission.
With regards to the submission that the timing and the date of the complaint and the examination of the complainant. Here, your lordship might kindly note that the complaint was filed on 27th of October. Thereafter, the civil suit followed. But when the complainant was examined, there is no deviation from the initial complaint which was filed in a written format and the statement which he has made, which is very necessary for examining whether the trial should proceed or not. There is no deviation from the narration in the criminal petition which has been filed and his initial deposition which happened even after the title suit has been initiated, your lordship. Here, yes, there is no deviation which does not clearly indicate that the prima facie materials cannot be established. First thing. Secondly, your lordship, when with regards to the talking of mutation and with regards to the idea of executive petition, there is a difference between mutation and possession. Mutation may be in their name, but when possession is in my particular name or with me, and I am in possession of the house, which is a matter of dispute as a part of mutation, then there will definitely arise a criminal liability when they will try to encroach or they will try to forcefully enter into the land or the property or the house where I have the possession. Here, I am in the criminal dispute with regards to the idea that my possession was tried to be disturbed. My possession, for disturbing the possession, they have used criminal force. And with regards to the mutation, a civil dispute is pending, your lordship. There is no necessity to meddle up both the mutation part and the possession part, your lordship. There is no denial of the fact that I was not in possession. I was definitely in possession. They used criminal force against me, pulled me out of my house, and in the course of the trial, along with other witnesses, and when I will have the opportunity of being cross-examined also, these things will come out whether to what gravity of the force was used, your lordship. At this stage, when the magistrate has issued and taken cognizance, the gravity of the offense is not brought into record, your lordship. That gravity will come out as a matter of trial, and in the trial, when the complainant will be examined again, and when the witnesses will be examined, and the accused person will have the right to support their evidences, it will come out with regard to the gravity and the heart which is occurred, your lordship. Here, merely the sections have been implicated so that the trial can be at motion, your lordship. So we are stating that it's a very nascent stage of this entire petition, criminal petition which has been filed, and therefore we are humbly requesting that this petition may continue as a part of the trial so that at the outcome it has been determined by the trial court and not based on prima facie materials which are just for putting it into motion. That would suffice, your lordship.
Yeah, the order is reserved.
My lord.
Arrest point, it's.
We wrapped it up by 4, my lord.
Huh?
We wrapped it up by
Yeah,
4
yeah.
o'clock. Deeply obliged, my lord.
Deeply.
And you said from yourself that it will be over by 4,
My lord.
including his
With
admitted.
my lord.
Deeply.
He won't in a hurry. Say that we're going to touch about it. Mr. Nawaz was there, I think, but we are not taking the further arguments today. We have a meeting, in fact. So you are for the respondent, I think.
Yeah, from respondent.
One will be listed after 1 week as on a date to be fixed. You to positive.
Lordship, 21 delay yet to condone, Lordship. It has come in admission column, Lordship. I have filed objection in this matter, Lordship, and delay is written in my petition wrongly, Lordship. In my service copy, delay is stated as 2,820. I have verified the record. It is 3,019. 3,019 days delay.
You have what you have mentioned in your petition?
2,820 days.
In my petition 2,820, as such, I have filed objection as 2,820, Lordship. Now I have verified it is 3,019.
No, is there any note from the registry about 3,019?
Yes, Lordship.
It is also been.
First petition is 3,019. And he supplied copy me
800.
2,820.
Actually, Lordship,
3,919.
19.
the registry verified the date and he advised us to calculate the dates. And according to him, we have calculated. It is
Whatever you have calculated.
200.
No. You have calculated the date and it is found that 3,019 days delay.
And
but the copy you have, which you have supplied to the other side,
Yes.
it goes this 2,000 something.
But it is actually 2,820, Lordship.
No, actually, I cannot say because you have quoted the 3,019 after using whitener.
No.
No, here you
Whitener.
have seen, here.
Original
copy, whitener is being used. Whitener. After using whitener, you have put 3019. How?
It is as per the
as per advice of the registry.
Yes,
But
Lord.
you have not put any initial in the below. If suppose there was an advice, or if suppose your whitener had to be used, there has to be your signature.
Yes.
That is also not the initial.
Yes,
is also not there then.
But actually, it was pending for some days for registry in the registry office.
Huh?
The case was pending in the registry office for many days, Lord.
It was defective. That's why it was lying before the registry, I think.
Let me correct, Lordship.
No, we are not in a position to say which one is correct. See,
The original one
other
is
side
correct.
has submitted.
Lordship, the original one is correct. The main copy that we have served to you, Lordship.
Registry has calculated 3,019.
Yes, Lordship.
I have seen verified the record.
So registry has calculated 3,019 days.
Lordship, and supplied me copy to 2,800.
So most probably
it may not be corrected.
Initially, they had
Lordship,
calculated something.
Yes, Lordship.
Copy was ready and that was furnished to you, and subsequently that
Yes,
correction is
Lordship.
made. But you have not put your any initial below your correction.
Initial is necessary.
That has to be there. That should be there in fact.
I have
If
filed
anyone
objection
can
also, writing as 2,820 days.
So
my objection petition is
on that basis,
2,820 days.
Now what to do? You want to correct it or?
My objection should be regarding 3,019 days.
Yes, it should.
But as he have supplied me wrong copy, I have also stated that portion wrongly.
Oh, okay, I can understand. Now you want to make it correction or want to file a fresh or what?
Oh, if Lordship permit me, I will go for correction, Lordship.
Or you can file an additional affidavit.
It's not a big act if you accept. I can give you the another copy.
Copy is correct, but I have already filed objection stating 2,820 days. And Lordship, it
On
should
that
be,
basis only, she already filed your objection on
Yes,
1,820.
then my objection should be treated as 3,019 days.
Okay, no issue. We can
It
hear
may
you.
not,
Lordship.
Our
only condonation, Lordship.
the points we have, which you have raised, or objection under which you have raised,
Lordship.
will be more or less same. It may be irrelevant of the fact that it is less, 1,000 less, but otherwise, more or less, it will be same.
Lordship.
Yes, Lordship.
So it may not affect you in that manner.
Yes, Lordship.
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 I think so. I don't know, but I'm saying.
Lordship.
Okay,
Okay, Lordship.
you have received the objection.
Yes, yes, Lordship.
Then also he has not cited me.
No, no.
Today I have
my
verified my
my
copy
copy
and
is
post
same.
copy. Then I come to know.
It is not a big matter. My copy is same also. But it may not be corrected at that time. Well, we have made 4 copies at the same time. We have corrected the registry copy, but not this one. This is the thing.
Okay, we are not going to hear the matter at this stage. We're fixing another day.
Lordship, and it should be come in a orders column. Lordship.
Better to come on order column. Yes. Because it is now in admission column, it should not be at. You are Mr.
Lordship, actually, it may be corrected or will continue.
Hear the matter. No, same on same thing.
Same, then condon maybe.
Only thing, Lordship,
will reflect, will reflect in your.
yes, yes.
Lordship, condon may be concluded.
You are
as-
Mr. Oh, it's
It is
3,000. Well, we have to hear. How can it be instantly condoned? Let us hear the matter. We are not in a position to hear the matter. I have a meeting at Safecourt. I think we don't have it. It's a good name. Your good name.
MM Rahman.
M. Rahman. Mr. M. Rahman, the land council for the petition.
Almost 1 year past, Lordship. Kindly give a short bit.
For the respondent. It is submitted to MS Bora that the respondent has already filed his written objection. Objection against the prayer for condemnation. However, she submitted that the copy which was supplied to her was the delay. The day of delay is mentioned as 2820, and on that basis only the written objection has been filed by her. However, on after perusal of the record only, it has come to her knowledge that the registry had calculated the delay of 3019 days, and in the original petition also the correction was made, and 3019 days are being inserted in the column. As the copy was supplied to her or delay for 280 days, the objection was considering the submission made by she raised the objection with regards to condonation of guilt, which may be considered at the time of hearing the interlocutor. List the matter in the let the matter be listed in the ordered column. Raised to the need. Want any fixed date here?
That
Next month, Lordship.
June.
8-10, yes.
10th of June.
Okay, okay.
10th of deep level.
Lordship.
Deep level.
Okay.
Beg your lordship, my lord. My lord, I just want to bring to your lordship's kind attention
Who
to.
is for the Mr. Chauhan? You are for the petitioner? You are for the petitioner?
My lord,
Okay, we will record your presence, but we are not going to hear the matter. So we'll just record it. Scan copy we have received already, na? Scan
It
copy
was
we have received.
called from us.
Yes, it's
Received.
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 We heard Mr. Chauhan, the learned counsel for the petition. Mr. SS S. Rahman, Learned
My lord, I'm SS A. Rahman, my lord.
A, sorry, sir. S.A. Rahman, Learned Counsel. Scan copy of petition has already been seen. Do you want any fixed date, Mr. Chauhan, or after 2 weeks?
My lord, subject to your lordship, my lord, kindly fix a date, my lord, subject to your lordship's convenience.
5th of June.
Highly obliged, my.
In a law. Orders.
Your lordship, the matter may be passed over for the day.
Pardon?
The matter may be passed over for the day, lordship. Because
Lordship. This is a revision petition against conviction. At this stage, on the last occasion, notice was issued against them. Therefore, at this stage, records may be called for and the petition may be admitted. Revision petition may be admitted and the lower court trial court records may be called for.
Yes, regarding admission,
Lordship,
you want to submit any?
the hearing both side, the petition may be admitted. Because primary counsel J.
No,
Kalita
no,
has to.
no, the petitioner side is submitting that it may be admitted and kept for final hearing.
Yes, sir.
Do you have any objection in admitting the revision petition?
The hearing both side, it may be admitted. Because
You
J.
need an
Kalita has
admission
to
hearing.
submit, he has to submit something, but
Lord.
he, due to having some personal difficulties, he has to leave the court.
Lordship, in this regard,
Any date may be fixed.
This year was not called for.
no, Lordship.
So case is pending.
Yes, sir. Lordship, in this regard, I have a small prayer. Since the case last date for in the trial court was on 5th of May, and we have submitted a petition regarding that the revision is still pending before this Honorable High Court, and there we have been given a last chance to furnish the order in regards to the IA that we have filed for suspension of order.
Okay. Somehow you manage that that the party cannot say anything now. The record is also not called for.
Yes, Lordship. Shorter date may be
So
given.
we'll do one thing, we'll call for the record.
Yes, sir.
If he wants that the admission matter may be admitted only after hearing or it may be disposed, then let it be given a time. We'll try to cooperate you. But Ms. P. Applicant and also you are Mr.
Yes, Kathak lordship.
S. Kathak, is submitted by Mr. Kathak that matter may be paid, Mr. Matter may be passed over for the day. As the your engaged counsel is J. Kalita.
J. Kalita.
Engaged counsel, Mr. J. Kalita. Is the inconvenient which it is report saying that the scan say was not called this as the respondent had already entered into appearance. Let the scan copy of the PCA be called from the concerned court. Registry will do the need. It was short, it means first week of June at best we try, but get them on a 4th of June. 4th of June. The other orders matter, all the orders matters have been adjourned today.
May I please, Lordship?
With effort, all matters are deferred. Okay.